Item number 1.
What page is this? Writ petition fails, the order passed by the Ombudsman is to be complied forthwith. In the facts and circumstances of the case, there shall be no order as to costs.
I agree. Yes, in this case, we have decided on 5 broader principle. Yes, all electricity councils, be careful. We have decided on 5 broader principles. 1, if there is concurrent finding of fact, and here we have found there is 2 courts involved with concurrent finding of fact. 2, the decision of both the authorities are by technical experts. High Court has no technical expertise on these issues. Therefore, High Court's exercise should be very, very limited. Then 3rd principle we have decided, unless there is perverse and decision against statutory provision. So High Court 226 has no jurisdiction to interfere in such orders. Then the 4th principle, once 2 authorities, expert bodies have decided, High Court cannot sit as an appellate authority. And the 5th principle we have decided, unless there is serious prejudice by the order impugned, High Court will be slow in interfering. And it is, we are offloading the judgment today. Please go through the judgment. Maybe I thank my learned brother. This will be first of its kind. Of course, we have taken support of a latest judgment of the Supreme Court also. So for Odisha High Court, it may be first judgment. And hereafter, we will be definitely expecting the electricity councils to argue dependent on the broader principles decided herein. And we will all try to avoid loss of time. Okay, Suna. It is both side and keep a copy of judgment there also. Let them also go through the judgment. Order to put the order for the FR, air kudava. Yes.
For admission, item number 2.
Yes.
Yes, earlier we had some, maybe a month back, we had requested bar members to provide us spiral bindings paper books.
That I have
Because
missed.
if you provide us a 2 kg brief or 4 kg, this may be 4 kg.
Yes.
Our table may not be sustained,
Yes, yes.
and my learned brother may be young, but I am too old. So I'll be damaging my hand. What to do? How to go through the papers?
I'll provide.
Not audible.
I'll provide you, Lordship. That spiral binding.
So we adjourn this matter. We
spiral
adjourn
binding.
this matter to at least Wednesday.
Okay.
You give us, you can split it
Ah.
in read petition along with annexures,
Yes.
counter
Hmm.
along with annexures, rejoinder along with annexures. You
Correct.
can keep it in 3 volumes so that we will start arguing.
A lot of affidavits have been.
Pardon?
Lot of affidavits have been given also thereafter.
That's right.
So
You
that
may
will be,
put,
that
you
will
may
be a
put,
part of that rejoinder.
you may put affidavits also in a
Yes.
punch,
Yes, yes, yes.
but and all of you,
Hmm.
all the sets of councils, you are requested to, we are giving you the brief. Please take note of the running pages
That's right.
so that in your Xerox,
Examination
those
should-
running pages must be telling.
Correct.
Otherwise, you can't just give us a load of 1,000 pages, 2,000 pages of brief and with one tag.
Can it be on
Adjourn
Friday?
this matter to
Can it be on Friday, Your Lordship? Because I'm not well. Can it be on Friday?
Friday.
Friday.
All right.
Right.
This court find is with the bulky brief herein. It is too much difficult to handle the papers in the course of argument. Direct the councils, respective councils to bring their pleadings in spiral binding and in volumes,
Yes.
different volumes.
Yes.
Yes, let such volumes be filed by Thursday with exchange of copy to the other side and the matter be placed again on Friday.
Yes.
Here, thank you, dear supporter. You ask your young counsel,
Yes,
senior
yes.
counsel.
I was remembering this now out of court.
Mask card de argue karun tapare pin
No,
debe apan.
Because I'm running fever, that is why I'm putting it on.
Pardon?
I'm running fever, that is why I'm putting
That's
it on.
right. All right. You
That's
can
right.
leave the court.
Again, say the matter was placed before Honorable Justice
God has
Parija.
helped you.
No, Justice
I
Parija.
never came knowing that you are in, or we never came knowing
No,
that you are
no.
suffering from fever.
No, Justice Parija told that you must arrange some handling allowance for this brief.
All right.
Okay.
Sooner you leave, it is better for the bar.
Yeah, right.
Please put your mask again.
Item number 3.
This is instruction for the bar wherever the brief exceeds 50 pages. This is instruction for all bar members. Yes. Yes, argue.
May I please, Lordship, as a glance to place them.
Yes, to save paper. To save paper, you can also get into both side preparations. Xerox both side କରିକି ବି ଦେଇପାରିବେ ସେଟା ରହିଲେ ତା ଭିତରେ ଆମର ବ୍ୟାକ୍ ସାଇଡ୍ ପଢିବାରେ କିଛି ଡିଫିକଲ୍ଟ ନାହିଁ ଏମିତି କଲା ବେଳକୁ କଣ କି ଏଠି ତଳୁ ପଡି ଯାଉଥିବ Yes, what is this issue?
Page number 90 will also be glance. The award passed by the Learned Labor Court, Sambalpur is under challenge will also.
Labor Court Award,
Madam.
Annexure,
Annexure will also 9,
page, ଯୋଉଟା ସବୁ ଆମେ ପଚାରିବୁ.
77 will also.
You should tell that
Madam.
in tandem.
Madam.
Yes, annexure 9, page
77 will also. 77.
77.
The operative.
छोट note काहे तयारी କରୁନାହାନ୍ତି?
I am suggesting
Brief.
I'm-
Reference ଟା ରହିବ ତା ଦେହରେ.
Sir, without contesting the
This
matter,
is
we have to
this is
discuss
10
this.
to award or section 2 award.
2A2, madam. 10-1 reference, 2A2 dismissal.
Section 10(1).
Madam.
You are management or workman?
And for the management will also. Will also has a glance to page number 90.
So management challenge.
Madam.
All right. What was the reference?
Reference is whether the will also has a glance to page number.
ଟିକେ argument କଲା ବେଳକୁ ଶୁଣନ୍ତୁ ଆପଣ ମାନେ mark କରି ପାରୁନାହାନ୍ତି. ଯେତେବେଳେ argument କରୁଛନ୍ତି you are taking your head down. But mic never goes down. Therefore keep your mic at the level of your mouth at least when you argue. Yes.
Will also has a glance to page number 78.
17
780.
70.
78. 78.
You know, why are you taking us to page 78? Why? What is the reference?
Reference is there whether the termination of service.
No. Please don't become a fool.
No, madam.
This is all live streaming.
75.
ମୁଁ କହିଦଉଛି ଶୁଣନ୍ତୁ ଏବେ ବି ଚିଫ ଜଷ୍ଟିସ କହିକି ଯାଇଛନ୍ତି ଆମକୁ ହେଡ କୁଲ ରଖିବାକୁ ପଡିବ 5 years. Because we don't know whether the labor court and industrial tribunal they completely correctly quote the reference or not. Therefore it is better always to go to the reference directly. So reference is answer 8.
Madam.
Page 75. Please read the reference.
Whether the termination of services of Sri Prasanna Kumar Das and 14 others workmen as per list enclosed by the management of Messrs. KJSS Steel and Power Division, Barpada District, Keonjhar, with effect from 6th of January 2012 by way of refusal of employment is legal and justified. If not, what relief these workmen are entitled?
Yes, right.
The object. While answering the reference.
Okay, whether the termination is proper, refusal of by way of refusal employment. So, okay, all right.
So, let's have a glance to page number 90. So, let's have a glance to page number 90.
The award. Yes.
1, 2, 3, 4, 5, 6. Line number 6 will also the workmen are entitled to be reinstated into service.
Time volume low rochi. Volume low rochi.
Mr. Panda, just bring it near your. Light ଜଳୁନି କଣ ତଳେ ଜଳୁଛି ନା କଣ ଲାଇଟ୍
ଜଳୁଛି ନାଇଁ ଲାଇଟ୍ ଜଳୁଛି ଲାଇଟ୍ ଜଳୁଛି but why volume is low?
ଫ୍ୟାନ୍ଟା sir ଫ୍ୟାନ୍ଟା ଚାଲିଛି
ସେ ପଙ୍ଖା ବନ୍ଦ କର
ଏସି ଚାଲୁନି ସେପଟେ ଟିକେ ଗରମ
ଏସି ଚାଲୁଛି ତ
ଆଜ୍ଞା
ହଁ ଏସି on ଅଛି yes now
ଆଜ୍ଞା the workmen are entitled to be reinstated into service.
ତଥାପି low ରହୁଛି
ତାପରେ ଏଇଟା ଏମିତି କର ରାଇଟ୍ ଉପରୁ କରୁଛନ୍ତି ତଳୁକୁ ତଳୁ କରିକି ଏମିତି ରଖନ୍ତୁ like as if you are speaking in a headphone.
The direction was the workmen are entitled to.
Please read it again. The reference is answer
on contest against the management but without cost. The action of the management in terminating the services of Prasanna Kumar Das and 14 others workmen by the management of Messrs. KJSS Steel and Power Division, Barpada District, Keonjhar, with effect from 6th of January 2012 by way of refusal of employment is held illegal and unjustified. The workmen are entitled to be reinstated into service with full back wages and other consequential benefits. The first party management is directed to restate the workmen on service.
ଆମ voice ଯାଉଛି ସେପଟ voice ଟା କାହିଁକି ଆସୁନି ଠିକ ସେ all right, therefore the reference is answered against the management with direction for reinstatement in service of all these people with full back wages.
My lord.
With full back wages. Okay.
There are 15.
So you must be paying 17B.
My lord, 17B payment has been done from the date of award till October 2022.
This is the award date.
Award dated, your lordship,
21st February
21st February
2017.
2017.
So what are you gaining?
No, my lord, I am suggesting that there are 15 persons are there. High people have already settled the issue by signing form K. They have joined and received some lump sum amount. Now there are 10 persons are there. Out of 10, 2 persons have got the age of superannuation. We have discussed with our client as also my senior. We are suggesting to my client, my learned brother, let them join within 15 days in the management. And regarding the constitutional pass as concerned, that may be referred to conciliation.
Yes, you join.
Yes, your lord.
Then we record that and close. Why to
My
keep this matter pending?
Oblige, your lord.
5% settlement already there.
My lord.
2 persons attended age of superannuation, therefore you are going on paying 17B, therefore there is no
till
question
the
of
age of superannuation. Till the age of superannuation. One has retired, Mr. Ashok Kumar De.
after joining superannuation face kala na nahi in the interim
Pending the rate
pending the application and while continuing 17B. While continuing 17B. So 2 persons attended age of superannuation. And the rest persons, they are agreeable to join.
8 persons.
Huh?
8 persons. 8 জন আগে.
Pardon?
8 persons.
8 persons. 8 persons. So total is 8 5 13 2 15 se 15 to thile ho. So you are settling in one way or other. So we record that yes, there is the rest of the persons, they are agreeable for settlement. Okay. And we close.
My lord. My lords.
Had the otherwise what was our impression is देखो आपण 17B दउचंदी last paid run they are sitting idle. You don't get any work. It is better you bring them to work and pay them. It is all foolish. If you continue in 17B for 10 years, what you are gaining ultimately?
Nothing.
That's why it is better. तांको से तो financial aspect रे you may have some settlement. या अदा नहीं हो जा सो चाकरी join कर.
Lossy may observe that.
Had the submissions of respective councils. This requisition involved an industrial adjudication decided by presiding officer Labor Court Sambalpur passing award dated 21st February 2017 involving ID case number 13 of 2012. The dispute involved the following reference. Page 75. Yes. The dispute was disposed of with the following award. Okay, 90. Page 90. In the commencement of submission, Management Council brought to the notice of the court that for admission of award passed by industrial adjudicator, management is complying the provisions at section 17B of the ID Act, thereby making payment of last pay to each of the workmen. In the pendency of the proceeding, there has been already settlement arrived with 5 of the petitioners. Entering into settlement in K form It is thus contended, dispute no more survives so far as these 5 persons concerned. At the same time, there is also submission by the counsel for the management that in the continuing of payment under section 17B, independence of the writ application, 17B of the ID Act, independence of the writ application, 2 of the petitioners have already been superannuated on their attending the normal age of superannuation. Therefore, in the meantime, issue relating to these 2 also gets resolved in the meantime. से दी जनक ପାଇଁ कोन करिवे आपण से तो रेगुलर हेलेनी
लमसम तो उडा बेनिफिट हम दे दो
लमसम
हम 3 लाख सर कर दियो
हे जेची
नहीं सर लमसम दिया ही
ओके दी
3 लाख को
3 लाख सर कर दियो से दी जण पे 3 लाख
मैनेजमेंट इज अटेम्प्टिंग टू settle issues with those 2 by on payment of lump sum in lieu of the estate. 3 lakhs को जो
मतलब 3 लाख
okay 3 lakhs hala. So this court find the there is no surviving of, there should not be surviving of any dispute so far as these two persons. Management also doesn't want to press the litigation for these 2 persons. So far as other 2 persons, on the submission of counsel for the management that there is settlement process with the other 8 workmen, and the workmen have already consented to join the services of the management within at least 15 days. Counsel appearing for the workmen also accept the submission of the counsel for the management. In the circumstance, this court find there is almost settlement involving all the workmen involved herein, requiring no further adjudication in the writ application. While disposing the writ application for cause of action not surviving, this court hope and expects the management will keep its commitment with the workmen involved herein. With this observation, the writ petition stand disposed.
कोई तो नहीं मैं कोई दे
गोटे स्लीप रे दे दियंतु से जो 5 जन को ना भिसा भिस पिटिशनर सो एंड सो ओके जो 2 जन सुपरएन्युएशन हेलेनी तांको ना भी दे दियंतु भिसा भिस पिटिशनर अपोजिट पार्टी नेम एंड द 8 तांकर भी गोटे सेपरेट शीट दे दियंतु दीज आर द पिटिशनर्स
टाइप करी सर दे दो लॉन्च आवर
ही सजेस्टिंग
गिविंग द टाइपिंग कॉपी
हां
टाइपिंग कॉपी दे देबी लॉन्च आवर
हां करी दे दो ना
My lord says
just extend it to court
one
and
small
give a
prayer,
copy to him.
small prayer from the both sides. Instead of the back conciliation to other issues, lump sum of 2 lakhs 50,000 may be awarded as the lump sum amount towards full and final.
आमे सेटा करबन सुनो
Sir, सर ठीक है
2.5 लिखि दोची
हां सर टू लॉस आई
मो 2.3
Suggesting-
जगह रे 2.5 लिखि दोची
नहीं नहीं सेटा 3 एटा 8 सेटा अलगा
नहीं ये 8 जन जो रजिस्ट्रेट हेबे
आगे
से 8 जन को अपन भी 2.5 लाख टका देबे कहू
हां सर इंडिविजुअल दे देले क्लोज इज वन इशू विल बी क्लोज्ड
Suggesting-
लिखिलो जे देयर इज settlement process along with the 8 opposite party 8 workmen so and so. There is also a proposal extended to these workmen to settle the arrear issue at rupees 2,50,000 each. तापरे होची the workmen counsel for the workmen has no dispute to this.
my name may be recorded your lordship
हाँ yes आपन
मिथुन दास
नहीं
अच्छी अच्छी
कौन कहले
मिथुन दास अच्छी सर
मिथुन दास
आगे आगे
सॉरी हाँ ये मिथुन दास का ना एपटे लिखि दबो आरो पटे रख सीनियर अछंती दुर्गा बाबू एठी
ऑप्शन सर
हाई कोर्ट रे अछन
आगे
तो
सर
होला ठीक है
may I pray your lordship जो सजेशन देले 2.5 लाख टका ଟିକେ ମୁଁ instruction ନେବି କି ନହେଲେ ଚଳିବ lordship?
How is?
No, drag
No, no,
କରନ୍ତୁନି sir. You lose the bus.
Yes, yes.
This is a
Very-
very.
Oblige,
Otherwise
oblige.
also,
Yes,
otherwise
yes.
also, ଆପଣ ମାନେ ଯଦି contest କରିଥାନ୍ତେ,
ଆଜ୍ଞା
ଆମେ backwages କୁ interfere definitely କରିଥାନ୍ତେ.
ଠିକ ଅଛି lordship.
Undisputedly, you
Aye.
have not worked.
ଆଜ୍ଞା
Undisputedly, you have no material that you remain unemployed for all these years.
yes.
Therefore, there is no justification in grant of full back wages.
Oblige lordship.
Therefore, you know the law.
Yes. Oblige lordship.
Item 4.
May I please? Yes, there are, IA has been filed for substitution of SAHOO with TPCODL.
I number 779 4457. This is you are for the consumer.
Yes, ma'am.
This is replacement of OP numbers
Pin number my lords.
2 and 3.
2 and 3.
କାଇଁ ଆଗରେ ଉପରେ ଟିକେ ଟିପିକି ରଖୁନାହାନ୍ତି?
ଆଜ୍ଞା ନାଇଁ ଦିଟା କନେକ୍ଟେଡ
ଏଗୁଡାକ
ମ୍ୟାଟର
ଶୁଣନ୍ତୁ ହାଇକୋର୍ଟ ଲେବୁଲ ଆର୍ଗୁମେଣ୍ଟ
ଦିଟା କନେକ୍ଟେଡ ମ୍ୟାଟର ଅଛି ତ,
ଇନଷ୍ଟେଡ
ସେଥିପାଇଁ
ଆନ୍ସର ଆସିବ.
ଆଜ୍ଞା 2 and 3.
This
I am
is an
also ready with
application, IA 4457 of 2023. This is an application to bring in replacement in the position of OP number 2 and 3. For there is change in the position of OP number 2 and 3 in the meantime. This court find there is genuine request, thus allowing the IA 4457 of 23. This court. Yes, have you filed the? But this 4 still continues.
My lords,
The role of 4 is therefore. Notice देखिए
franchisee has ended.
Are you filing the consolidated?
Yes, my lords, I am ready.
There is filing of consolidated first title with service of copy. Yes, with service of copy be kept on record. Now, what happened to OP number 4?
As OP number 4, the company exists, but the franchisee has ended.
Franchise has changed.
Yes, my lord.
No, term over.
Mr. Falguni Mahapatra na? Sorry, Vikas Jana. Mr. Jana,
My lord.
we find OP number 4 is not turning.
Yes.
Then you must establish that there is subsequent agreement with the further franchisee and the burden of this franchisee has been shifted to him.
My lords,
Otherwise, we can't interfere in the order.
my lords, the term of the agreement, franchisee agreement has
You should
expired.
have.
It has
You should
expired.
have.
My lord.
You should have. Otherwise, it's not our responsibility.
My lord, since the
This OP number 4 is no more surviving.
yes, my lord.
Therefore, he is not coming to contest.
Yes, my lord.
So, show the agreement of the other franchisee that this burden, all these burdens have been shifted to him.
No, my lord, there is no further agreement, any franchise agreement subsequent to this.
Then it goes.
So,
Then it goes for the technical difficulty will be dismissing.
my lord, because the once,
No, say,
My
no,
lords.
because what prashna nahi.
my lord, here in the order, my lord,
Question is, there should be a lawful decision
my lord,
in the contest of the parties.
my lord,
Party is not joining.
my lord,
Party is not joining.
my lord.
You can't bring the new franchisee because there is no transfer of assignment to the new franchisee.
Right.
So in the if at all a burden will come, it will be a burden on OP number 4.
And that's, no, my lord, the
What-
burden,
What happened to the notice?
Well-
Suppose in spite of notice he is not turning.
my lord,
Let us see what happened to the notice on OP number 4.
my lord, the notice has been made sufficient
Notice,
Because-
देखिए notice इस वाला case रहे.
because in the connected person, I think,
It is not to connected. Here we have to find whether notice is sufficient or not.
some lawyer was appearing for the
Virus
franchise.
challenge कले,
Notice ହେଇଛି।
register ला, केबे notice issue वाला, 2 to 5 be taken. 2 to 5 रे आपण requisites file कले. Yes, requisites रे 16/8 हैला, fix हैला date. Then AD return from OP 1 to 4. He is not volunteering. Therefore, I am not participating. This court find there is already service of notice on OP number 4. Despite that, OP 4 is not attending to the hearing proceeding. Now, argue.
Sir, perhaps I have
Have you appeared for the?
appeared perhaps my Bhakalatana is with my lord. Lord, you may see.
Pardon? You have filed a vokalatnama?
Yes, my lord. 17/8/2016. I have appeared for 2 to 5.
You have filed a fresh vokalatnama? When?
My lord, my lord, it is filed on 17/8/2016. My Bhakalatana.
No,
From
17/8.
OP 2 to 5 I have appeared. OP already, OP number 2 to 5. 2 is blood that
2 to
license.
5 you have appeared.
Yes, my lord.
Okay, then 4 is already there.
That is the executive engineer and that franchise.
Okay. তাহলে সেটা
4 and 5.
না করে কি লেখো Sri Das Learned Council already appeared for OP number 2 to 5. All right, now even assuming 16 ठीक है. So now where is the fresh vokalatnama? There is change in party.
2 to 3 minutes I have not filed.
2, 3, you have no vokalatnama.
I have not filed. Fresh today it is allowed.
So are you undertaking or will issue notice?
Your lord, issue notice. my lord.
Notice kariba. All right, Sri Das.
So before that, may I submit, my lord, this matter is already covered by a judgment of the in a written-
Covered in allowing in favor of petitioner or
Yes,
against?
yes, my lord.
Allowing unless we
All
hear,
right.
we can't decide.
Yes, ma'am. Whatever your lords.
So therefore, Mr. Das declined to appear for the newly added OP number 2 and 3. In the contingency, this court feels it appropriate to direct fresh notice to OP number 2 and 3. The newly added parties herein. Requisites as undertaken be filed by day after tomorrow. Considering matter is pending since 2017. The notice on the newly added OP number 2 and 3 be issued forthwith, fixing short returnable date, and matter may be listed immediately after service on the OP number 2 and 3 is sufficient. Yes. Any interim order?
Yes, my lords. 6/7/2017. There.
Recovery from petitioner in persons impugned order issued by ATE shall remain stayed. All right, interim order to continue.
In the connected matter, I have also filed an IA and consolidated
ସେଥିରେ
custody,
IA କେତେ?
and that is 4456.
Second case रे IA number 4456.
Again,
Same 2 and 3.
again.
Yes, 2 and 3. ହେଲା same order ହବ. ଏଠି ବି ଦାସ appear କରୁଥିଲେ. Yes, decline to appear. Yes, Mr. ବଳ କାହାନ୍ତି?
He was
3
along
to
with
4
me.
ପାଇଁ Mr.
My
ବଳ
lord, he was along with me. my lord.
along with you.
My lord.
All right, decline to say order ରହିବ. Same notice. Here also interim order.
Yes,
All right.
consolidated cost title I have filed.
Yes, next.
Obliged.
But
Item
four,
five,
but four पे आपण continue करिए.
Again.
item 5,
Power of Mr. Das presently confined for OP number 4.
4 and 5.
4 and 5 होची first case रे, second case रे होची 4. Yes.
item 5,
My lord, in item number 5, I am appearing for opposite party number 15.
Who is for petitioner?
Lordship, I am for the petition.
You are for petitioner?
Lordship. In fact, Lordship, yeah, a glance to the prayer portion.
Please set the mic.
If you Lordship look at the prayer, that Lordship, the first prayer is no more survives Lordship first prayer.
Let us read the prayer.
Lordship.
Why the order of disengagement dated 18/12/18 by the annesso 1
One, and so goes
and
under Annex
so
7
under 7 shall not be quashed.
quashed. Declare the same as illegal.
So this disengagement is taken out.
In fact, Lordship, there was a allowed a strike called by this organization. That's a common order passed to disengage all the employees who are in strike. So that is
By the annesso 7.
seven was the show cause notice. Annex 1 was they were issued notice for disengagement. But subsequently, by intervention this Hon'Ble Court Lordship, now they are working and the prayer is no more survives
So
Lordship.
prayer 1 doesn't survive.
And
এটা
prayer-
ଗୋଟେ similar issue ଥିଲା କି?
Similarly, so for regularization part is concerned, Lordship, kindly say this coordinate bench has given a
So it is covered by this judgment.
just we want to add something, Lordship, more.
No, but we can't go beyond that or behind this.
Now, here is a case, Lord, we are claiming for regularization 100% reservation. So far the rules is concerned, because Lordship, the case is like this, Lordship. These persons are working at Gram Rozgar Sevaks, Lordship. It is arising of the central scheme, the central statute, that is MG Energy Act 2005. And both state government and central government has made their guidelines, and we are working under the Gram Panchayat.
So Mr. Dalai, the cause of action only survives on so-called annesso 7.
No, Lordship. Now, my Lord, so far the regulation part we are claiming, Lordship.
Huh?
So far regularization part is concerned,
Huh.
that is only survives, Lordship, because we are claiming for.
So statute अनुसार तो हब that judgment notes there has been an amendment which provides for regularization.
Regulation
So it
30,
should not be agreed and regulation, if any statute is there, this court cannot go beyond that also.
And these are,
Have you checked that paragraph?
yes, Lordship, I have gone.
Damodar Naik, the prayer was same, I think.
So far, no, in that,
brief ta achi ki? Damodar Naik brief
that-
kaha pakhre apan pakhre achi?
that case,
No,
I was the council, Lordship, I was the council
Yes,
there.
yes, that is how the same comes.
In that case, rules were under challenge. That's why Lordship has held that no, 30% is good, and further direction has been given.
para 12 of the judgment.
Para 12, Lordship,
No,
para,
let us come to prayer of this.
Lordship,
Here the cause of action is twofold.
Lordship,
One is as to why order of disengagement by the annesso 1 will not be interfered,
Lordship,
and so cause under 7 series shall not be quashed.
Quashed.
That's all.
Lordship.
That's all the prayer.
That thought I have to go, Lordship.
That's all the prayer.
With further direction, Lordship, that is.
So regularization ସେଟା ସରିଗଲାଣି ଆପଣ regular ହେଇଗଲେଣି
Na regular ହେଇନି. ସେମିତି contractual କାମ କରୁଛୁ.
huh?
Contractual ଅଛି. Still we are working contract. Since
So
2006,
actually-
But you say the disengagement has been taken out.
this can get taken away. So we are working as a contractual employee, Lordship.
Okay, now so only regularization aspect is surviving.
Only surprise, Lordship.
Okay.
Oh.
So if regularization aspect, what is the rule for regularization?
Lordship,
That the other judgment takes care.
Yes,
That the other judgment takes care that 70%, 30%. So you are covered, well covered by this judgment.
Lordship,
Had the submission of respective councils. This writ petition involved the following prayer. Considering the rival contention this court find involving similar prayer, there has been already decision of a coordinate bench in the disposal of WPC 12688 of 2013,
Para 13, Lordship. Para 13.
giving, deciding the application, deciding the said repetition in terms of observations in para 11, 12, 13 and 14. Considering the submission of respective counsel, this court find the prayer herein is well taken care of in the judgment decided in the case decided in WPC 12688 of 2013. This court therefore in the disposal of this writ petition declares the case of the petitioner shall be governed under the observation and directions in para 11 to 14 therein. Before parting with the case, this court records the statement of Sri Dolai that the issue so far as disengagement involved in the writ application doesn't survive.
Lordship. Grateful.
With this observation, the writ petition stand disposed. Yes.
Item 6.
One more sentence, may I add, Lordship? May I make a prayer to OP number 1 to redress my grievance, Lordship, in view of the judgment?
Yes. If any cause of action survives, it may be open to the petitioner to bring further request before the competent authority for
OP
their
1,
lawful decision.
OP 1, Lordship. Grateful, Lordship.
Yes. Yes, item 6.
My lord, may I please your lordships?
Yes.
My lord, here, my lord, your lordship may kindly call this matter next week. I will be filing an application to change the OP number 2 and 3 because it is NESCO, my lords. No, I have Tata Power North. That has not been done. And on the last occasion when the matter was there, my lords, I was in bereavement, my lords. I am also disturbed till.
No, that's right, but Mr. Mishra, we don't appreciate when the matter comes, then only a prayer will come.
No, because
You can ask your associate to find out all such matters and take steps on
My
your
that-
own.
That is, but client, he is coming on day after tomorrow, my lords. My lords, I have contacted him
That's
after the
right,
matter.
that's right. Why the steps are taken after the matter comes on board?
Sir, client associate, sir,
No, ଆପଣ ଶୁଣନ୍ତୁ ଆମ ଚାମ୍ବର ମାନଙ୍କରେ ଆମେ ମଧ୍ୟ ପ୍ରତି ସମର ଭେକେସନ ରେ we used to issue postcards to clients ଯେ ତାଙ୍କର interest ଅଛି କି ନାହିଁ, କିଛି development ହେଇଯାଇଛି କି?
Yes, I have been told several times.
So ଆପଣଙ୍କ ଚାମ୍ବରରେ ଆପଣ ମାନେ ଆଜିକାଲି ଚାମ୍ବରରେ ସେଗୁଡା Mishra and counsel for the petitioner seeks time to bring in change in the position of some of the opposite parties. For there is already change in the position of some of the opposite parties in the meantime. Place this matter after vacation along with Miss Case, if any.
I have filed 2 fresh Bhagatna Lordship.
Yes, Mr. Tripathi. Dita case re?
Dita case.
Okay.
Fresh Bhagatna.
File fresh book. कहाँ पे file करते?
1 and 2. The license.
नहीं 1 and 2 माने party likely to be added or?
No, 1, 2 is the contesting party, that is licensing.
ଆପଣ ଏଥିରେ opposite party ନା ଆପଣ wait କରନ୍ତୁ
Opposite.
because they have not changed. ଆପଣ wait ସେତେବେଳେ file କଲେ better
ସେ
ହବ।
ତାକୁ ବା change କରିବେ କହୁଛନ୍ତି
ନକଲେ ସେ
ଆପଣ
case ଗଲା ସେ।
ସେ ତ change ଏପର୍ଯ୍ୟନ୍ତ କରିନାହାନ୍ତି।
And then
Keep it with you. You have done the right thing as has been observed by my lord.
ଦେଇଦିଅ।
and here is
ରଖନ୍ତୁ when he as and when he
ସେ
files
consolidated ଯେବେ file କରିବେ ଆପଣ
let such application be ସେଟା after vacation ନ କରିକିରି ଲେଖ let such application be brought within 10 days. They say the order is peremptory. Failure of filing such application, the matter will be dismissed without reference to bench.
Lord, may I pray, my lord's interim order to continue till then.
Interim order to continue. Yes, 10 days with a non-ele matter dismiss ହେଇଯିବ.
ନିଶ୍ଚୟ ନେବେ ସେ ପରଦିନ ଆସୁଛି so I'll be doing by this week my lord.
ଦେଖନ୍ତୁ find out କାହିଁକି ନା ଆମେ 19 ର ମ୍ୟାଟର କୁ କାହିଁକି ଆମେ ଏତେ
Yes.
lenient ହବୁ? Yes, next.
Item
Obliged.
7.
My lord, I'm appearing on behalf of Mr. Prafulla Kumar.
7 ରେ ଗୋଟେ କାମ କରିବା ଶୁଣନ୍ତୁ Mr. Prafulla Kumar Rath. ହେଲା। Hello. Registry directed to place the matter before Honorable Chief Justice. Seeking direction to place this matter where Justice Biswanath Rath is not a party.
And in this matter, we are appearing for opposite party 5 minor.
So
We
na
pray
likhi-
2 week time.
na likhi diyo samasta.
Opposite party 5. PC.
Ye.
We pray 2 weeks time to file.
ଆଜ୍ଞା ମୁଁ ଶୁଣିବିନି କହିଲି
Adjourn.
ତେଣୁ ବର୍ତ୍ତମାନ ଯିବ ଚିଫ ଙ୍କ ପାଖକୁ କାହା ପାଖରେ ଆସିବ you are getting automatic adjournment. Why are you bothering now? ଇଏ ତାଙ୍କ ପ୍ରତାପ ମହାପାତ୍ର ନା ନାହିଁ ଆପଣ ନା ନାହିଁ ହଁ ଲିଷ୍ଟରେ ଅଛି ପ୍ରତାପ ମହାପାତ୍ରଙ୍କୁ ଚିହ୍ନ ଆଚ୍ଛା ହଉ ଠିକ ଅଛି.
Item 8.
Yes, now matter will be placed somewhere else. Okay. Yes.
Item regarding regulation of DLR in the work charge establishment, that is the single bench.
Single bench matter, the ball policy.
Single bench matter.
Yeah, thank you. Earlier he had approached this on Court, and his prayer was for allowing him to join as a watcher's employee. And he had a repeat to that effect and direction.
No, but if you find this is a single bench assignment,
Again, it only with good line by matter doubt who say minimum wage kotha likhi dଉଛନ୍ତି and consequential relief under the minimum wages act.
so therefore
नहीं वार्चार्ज रे तो मिनिमम किसी नहीं ना वार्चार रूल अनुसार पाइबे.
Again.
Yes.
Na seta reject heଇ ଯାଇଛି. That prayer has been rejected.
he is drawing attraction of the provisions of the
Yes.
Minimum Wages Act.
Minimum wage କରୁଛନ୍ତି.
Therefore single bench କୁ କାହିଁକି ଯିବ?
ନା ଏଠି ଆପଣ
ଆମେ decide କରିବୁ minimum wages applicable ହବ ନ ହବ.
that is one thing. Not second thing is that even if he claims for minimum wage law, then he has to go before the
Let us hear him.
again.
Let us hear him.
नहीं वार्चार्ज एस्टेब्लिशमेंट को आसिलेनी से.
Now, he actually he was engaged during the ban period. Then in 1999 he absconded. Thereafter, he after much lapse of time, he came.
What is your case? What is your case?
The representation was directed by Annexer 8, saying that the petitioner is absconded from the.
Mr. Barik,
Yes, ma'am.
please take note of this. We must get the hint. What fell from my lord? If you are yet to be engaged as a Warchast employee, you are seeking for payment of minimum wages, then as he said, you have to go to the authority.
Yes, ma'am.
So don't take a observation from this court that whether you abandoned voluntarily, you are whether you absconded and all these things. Don't raise those issues here, which will prejudice you
Yes, ma'am.
ultimately.
Malak, I am just passing over the additional affidavit whether the present action taken by.
First you argue the writ petition, let them respond, then you file additional affidavit, whatever.
Make your submission.
Yes, ma'am.
Make your submission. What is your case here?
Yes, ma'am. To take over the petitioner to the workers
You
establishment.
had earlier come to this court.
Yes, ma'am.
So earlier writ petition, what was the case there?
That is the representation to take over the petitioner as workers employee.
Decided page 20.
Yes, my lord.
Yes,
That has been
read the
rejected.
order.
That was decided to dispose of
Read the order. Read the order.
the writ direction that
Page
disposal order.
20 order.
Yes, ma'am. The petitioner filed this petition praying for a direction to the engineering chief civil works department once or to engage him as workers employee in RWC Anandpur in pursuance to government circular dated 12/12/2013 and 12/1/2018 and to disperse the arrears salary from 2011
So
under
therefore,
minimum. wages.
earlier also it was under the minimum wages. Act.
Yes, ma'am.
Okay, now this was your prayer.
Yes,
Then
ma'am.
what has been decided?
That is decided by the
Considering the submission of land council, padondu.
Considering the submission of the Learned Counsel, the court dispose of the representation with a direction to the Indian Chief Rural Works Department one, sir, to dispose of the representation by the Annexure 5 within a period of 3 months from the date of production of certified copy.
Thereafter, what happened? Have you
That-
made a representation?
Yes, my lord. That in the rate application Annexure 5, that was I have also here in. marked as
Annexure
file.
8.
Uh,
Annexure 8 is the order of
Annexure
rejection.
8 is the rejection order.
Let us go chronology. You have come prepared. We are not prepared.
Sorry.
We are presumed to be not prepared because we want to give a justice here. ଆମେ ଯଦି ସବୁ ରେଡି ହେଇକିରି ଆସିବୁ କହିଦବୁ ତାହେଲେ ଆଉ ରହିବ କେସରେ କଣ? So therefore we are going step by step. This is the direction of the single bench. You go make a representation. Then where is your representation?
That is at page 17.
Page?
Page 17 of the
Page 17.
Annexure 5.
Okay, this order was passed on 5/7/18.
Yes, madam.
Come to page 17.
That is the representation addressed to the engineer chief.
Sorry, that's not the representation in terms of the High Court. High Court judgment was passed when?
On
Come to
5/7
page 20 again.
5/7/18.
Kete?
5/7/2018. 18.
5/7/2018.
Yes, madam.
What is the representation you are referring? What is the date?
That
So this can't be a representation pursuant to High Court direction.
Yes, madam.
So therefore, if you want to go by Annexure 5, don't refer to earlier High Court direction. Because you have suppressed before the High Court that your application was already pending by the time the High Court is adjudicating. Otherwise, High Court would have recorded there is a pendency of the.
Actually, there is no
Annexure
suppression.
Annexure 8 is the.
ଟିକେ କହିଦଉଛି। By the time he approached this honorable court, the representation was
All right.
pending.
Even assuming a representation was pending. Okay. Now there is a decision. So what is the flaw in that decision? What is the flaw in that decision? Annexure 8 you are challenging virtually?
Yes, madam.
So what is the flaw?
Madam, thereafter, my lord, I have prepared an additional
Se
affidavit.
representation ta kahaku karthile koile?
Engineering chief river works, OP number 2.
Engineer in chief.
Yes, madam.
But you are claiming in terms of minimum wages. You are claiming in terms of minimum wages.
Yes, madam.
So who will be the appropriate authority?
The petitioner was serving under the.
He might be serving.
Yes, madam.
So complaint will be lying to whom?
But
He
there
has given you best suggestion.
the prayer is two parts, my lord. Some area wages as well as for taking over into the work charge establishment.
Yes, so Annexure 5, let us see what was your prayer. Pray your honor to kindly consider my case to engage me.
To engage me as
work
work charge in RW section Anand
as per this so and so.
for working beyond after cut-off date 12 for
So there is no involvement of minimum wages at all.
No.
There's no involvement
Yes, madam.
to treat you as the work charge employee and also releasing the area
Some
salary.
area wages
Okay.
that
Did-
when I rejected the representation.
Paid the minimum wages.
Yes, madam. That representation he The
Then why
representation,
don't you make an approach to the authority under the minimum?
that is Annexure 5 itself.
No, Annexure 5 is not that. Annexure 5 is you should be brought to Varchas
Yes, my lord.
and accordingly you should be paid area.
Thereafter, my lords, the petitioner also filed a representation to the authorities that I am producing this additional affidavit, where there is a subsequent
No,
development.
additional affidavit that cannot come in as a cause of action here. Because it is based on a direction of this court already.
Yes, ma'am.
So if you have made a further representation.
That a subsequent development has been made regarding the regularization of this petitioner as a versus
Then you
employed
withdraw
that.
this, bring a fresh writ application if further cause of action there.
Covering the decision of the.
Consolidated cause of action ranadu, writ petition.
My lord, there is an Honorable Supreme Court decision in the Narendra Kumar Tiwari matters that is covered by the decision of the Honorable Supreme Court decision. That Narendra Kumar Tiwari, that has also decision I have given this the additional affidavit. In behalf of that, the matter may be disposed of.
Listen, dekhe.
In the last after page 11, that has been not been page back.
We can at best say your pending representation may be considered in keeping in view this decision.
This, my lord, great respect, my lord, this judgment will not be applicable because he absconded. Page 25, your lordship, may kindly have you. Page 25.
No, now he is not on that issue. He says there has been some Supreme Court decision which is likely to be covering his case. And at the same time, he says he has already a pending representation of that.
If he has done.
So therefore, we don't express any opinion in the writ application now, leaving it open to the authority to take a decision on his pending representation. And also, while also keeping in view the applicability of this decision.
Yes.
So let them take a lawful decision
Because
thereafter.
the specific finding of the authority concerned is that.
Absolutely. Correct.
99 he absconded. 93
we are not
despite the
expressing
ban
any
order he
opinion.
joined.
Mr. Ghosh, we are not expressing any opinion on that. Had in the course of submission, it has been brought. Tangoda copy
Already given.
By way of additional affidavit, it has been brought to the notice of the court. That in the meantime, petitioner has a further representation dated 26/3/2018.
No, that is the earlier reputation. 26/3 earlier. You would say read.
Oh, they say annexure 5. Here annexure 3.
Again, no, see you representation.
It should be annexure 5.
Here annexure 9 series of my additional affidavit. Here annexure 9 series of my additional affidavit.
18 9 series रे तो आपण सेही 26/3/18 कथा लिखुचंती 26/3/18 टा देखिबा आ अलगा रिप्रेजेंटेशन की
that is another
अलगा होची
अलगा
page 3 रे page 3 रे जोटा होची सेटा
अलगा
अलगा
हां
and a subsequent development is annexure 9 series and 10 series
filed here in the additional affidavit as annexure 9. Counsel for the petitioner claims such application is pending and wants to take advantage of a judgment of the Honorable Apex Court reported in AR 2018 Supreme Court 3589 for the subsequent cause of action, this court, without expression of any opinion on the issue involving the writ application presently, disposes the same, simply observing in the event representation of the petitioner by the Annexure 9 series appended to additional affidavit dated 4/5/23 is still pending consideration. The authority taking required to take decision shall do well in considering such representation and disposing the same. However, examining if the decision in AR 2018 Supreme Court 3589 applicable to the case at hand or not. Entire exercise involving Annexure 9 involving hearing be completed within a period of 2 months from the date of communication of order of this court. But Mr. Counsel,
Yes, ma'am.
henceforth take a careful role. You are Mr. Bari.
Yes, my lord.
If you want to bring further materials to the fold of consideration, what is the procedure?
It should,
What is the procedure?
it should be filed in the registry. It should be filed in prior to placing of the matter should be placed for the registry for
It should be filed by way of
by the registry, my lord.
huh?
By the registry.
Oh, sorry. କାଇଁ ଆମେ ଏତେ ବୟସ ହେଲାଣି ଆମର ଫଣ୍ଡାମେଣ୍ଟାଲ କାଇଁ କ୍ଲିୟର ହଉନି?
Amendment ଟା କରିବେ ନା?
What the writ court consider? Pleadings in the writ application and the documents
Yes, ma'am.
appended thereto. Is it a document appended to the writ petition?
So, my lord.
Then how this document comes in a writ petition? How this document comes in a writ petition?
By filing in proper format.
What is that format? You should bring amendment to the pleading.
Yes, my lord.
କାଇଁ ହଉନି କାହିଁକି? Additional affidavit should be simply thrown out. This is not a cause of action. We can very well reject.
So hence
Please be careful. ଯଦି ଆପଣଙ୍କ ନୂଆ cause of action, nobody prevents you. Pending writ application, some development. Bring amendment. ପରେ ଆଉ ଏଇ mistake କରିବେନି.
I'll take care of it. Lord.
Item 9,
My lord, I am telling the opposite party.
Yes.
I am telling the opposite party number 3, my lord.
ଆପଣ ଉପରକୁ ଯାଇପାରିବେନି. ମାଇକ୍ କୁ ତଳକୁ ଆଣନ୍ତୁ.
Mic ଟା କଣ?
ହେଇ ବୁଝିଲେନି ତଥାପି. କଣ କହିଲି? ଆମେ କଣ କହିଲୁ?
ତଳକୁ କଣ?
My lord, I am challenge opposite.
ଶୁଭୁନି ତଥାପି ଆହୁରି ମାଇକ୍ ତଳକୁ ଆଣନ୍ତୁ. ମାଇକ୍ ତଳକୁ ଆଣନ୍ତୁ. ହଁ.
My lord, I am challenge the opposite matter number 3. My lord, petitioner is a domestic.
Raise your voice. Raise your voice. Your voice is not audible.
My lord, petitioner is a domestic consumer belong to consumer number 52311170570 CPD number 571 relating to the meter number
So
165.
ombudsman order is challenged.
Yes, my lord.
That
Of village
will be
Ijida under opposite party number 1. Petitioner is a regular paid consumer and was paying the electric bill, but when the electric is not consumed from the month of February and March, based on Otis shop.
Just 1 minute, madam. Don't run.
Kindly just wait.
You have
ଏଇଟା ଗୋଟେ ତଳକୁ କରିଦେଲେ ସ୍ପିକର ଟା ତାହେଲେ ଆପଣ
You are-
ପାର୍ଟି କାହାକୁ କରିଛନ୍ତି ଦେଖନ୍ତୁ. Lordship is looking at your page 1 and 2. ଦେଖନ୍ତୁ.
1 ରେ ଦେଖିଲେ କାହାକୁ ପକ୍ଷ
ଆପଣ ରାଇରଙ୍ଗପୁର ମୟୂରଭଞ୍ଜ ନା?
Yes, my lord.
ଆପଣ ପାର୍ଟି କାହାକୁ କଲେ ଦେଖନ୍ତୁ 1 କୁ. Just kindly look the SDO electrical subdivision SESCO.
Yes.
ଆଉ ଶେଷକୁ ଅଛି କି?
ସେଟା NESCO ଥିଲା ସେତେବେଳେ. From the day 1 you have there is a misgender of party. North Odisha. SESCO, NESCO, South Co.
एक तो भूल पार्टी करछन्ती दुई रे एभली पार्टी जे भी ओम्बुड्समैन रे थिला से भली पार्टी वर्तमान नाही सबु टीपीडीसी डीसीएल और टीपीओ डीसीएल दे साला
पेज 19 देखंतु kindly mark page 19 annexure 4 nesco utility Rairangpur. So you bring amendment.
तो प्रलंब असुदी देखो तो पेज 18 रे कॉपी दिया हिची सब एसडीओ इलेक्ट्रिकल सब डिवीजन नेस्को रायरंगपुर तो प्रलंब असुदी ये ताको एंटरटेन भी करि पकेले 19 रो मैटर 22 रे टेक ऑफ हला
मु तो निजे पढ़
22 रे टेक ऑफ हला कोन अछि कि मेरिट अछि रिसर्च कर
Was the disconnection stayed? Learned Council, the disconnection was stayed by the High Court.
नहीं
If the disconnection notice has not been stayed, then what remains in last after 4 years?
काई आपको फाइट करछन्दी आपण तांग संगे सेटल न करी करी आपण एटा घरटा दे एटा गोटे इंडिविजुअल दिस इंडिविजुअल इट्स ए इंडिविजुअल कनेक्शन
Of those matters are
से
dismissed.
भितर नहीं सारिबणी के आपण कांटेक्ट करथिले भितर पार्टी को नहीं मो नो इंस्ट्रक्शन रे रिजेक्ट कर दोछ काना 4 वर्ष होला गोटे पार्टी बिना पावर रे नथिबो
सेटा टाटा जो
हैं
एबे तो
आमे नो इंस्ट्रक्शन रे रिजेक्ट करूछु आपण पार्टी को डकांतु जदि पार्टी पावरलेस अछि घरे पावर नाही विदाउट पावर अछि ताले यू कैन रिवाइव द एप्लीकेशन बट नो पर्पस इन कीपिंग दिस
सर
मैटर
देलेनी जो टाटा देलेनी पावर देलेनी
पार दे सरलेनी
हां
हां ताला कोन कहजो
Page 8, kindly see the order of GRF that is in not prejudicial to any one of the parties.
पार दे सरलेनी कहूची
The forum feels that the energy bill of the complainant ought to be revised observing the regulation of OERC Code 2004.
सरला तनु
This was
सेटलमेंट
the observation of my lord in the beginning today, that when it is not prejudicial to the consumer, we are not going to interfere.
सर excess bill
That excess bill is to be a method of calculation to be adopted by them. That is the direction. After that, whether it is excess or not, that you can raise a grievance before the GRF. The GRF has passed a order that to revise the bill in accordance with 2004 code, OERC 2004.
it is rather supporting you
It is supporting you and not prejudicial to any one of you.
but my lord the ombudsman dismissed the case of the petitioner without pursuing the documents and without calling prepare testing report
Because you challenge that order. You see that annexer that at page 9,
the copy of
that the electric bill that is to be revised by following the 2004 regulation. That is the order. You have challenged that order which was in favor of you. And don't expect
Upon
a
the
GRF will say
relief-
that you don't have to pay anything.
आपण रिलीफ देहिची
And never expect that you will get a order that don't have to pay anything and consume electricity. No forum will grant that relief to you. If there may be a grievance that there is some error, calculation is wrong, or the method of calculation is wrong.
I had the submission of
It's a billing dispute.
The repetition involved the following prayer. In the first instance, it appears the petitioner visited the grievance redressal forum involving alleged illegal raising of bill. Registered as GRF CC 42 of 19. Expert body through the GRF passed the following order. Page 8. Petitioner appears being dissatisfied with this order. Consumer. Referred consumer representation case number OM/2/N-12 of 2019. On the file of the Ombudsman 2 Odisha Electricity Regulatory Commission. This matter has come to be disposed involving contest of the parties with following direction. Page 18. Reading the aforesaid, this court find there is confirmation by the, first of all, the GRF passed a favorable order in favor of the petitioner. We don't find any prejudice to the petitioner thereby. Secondly, the order of the GRF has been confirmed in the disposal of the consumer representation, appearing at page 18. All this happened in the year 2019. In the meantime, 4 years have passed. There is no stay order operating. Besides, in the course of submission, learned counsel for the petitioner submits. In the meantime, there has been already power supply to the petitioner's residence. And the learned counsel has not been instructed any further. Okay, it is on the ground that there is no prejudice to the, on the finding that there is no prejudice to the petitioner by the order of the GRF by Annexure 1. Further, there is no further instruction to the petitioner, counsel for the petitioner by the petitioner, and also keeping in view that there has been power supply to the petitioner's residence on the submission of learned counsel for the petitioner. This court finds this is not a fit case to be entertained any further, disposed accordingly.
Item 10.
May I please, Your Lordships? Your Lordships, in item number 10, I'm filing a written notes of submissions. And
Pardon?
Lordships, in item number 10, I'm filing a written notes of submissions and citations.
Yeah.
And I'm paying for an adjournment, Your Lordship.
No adjournment. No adjournment. This is a matter of 22. It has come for hearing. Why you take adjournment on the ground of filing? You are filing, you argue.
Your Lordships.
Argue.
Your Lordships, actually, my senior is in a part-heard
Then
matter.
that should have been your first submission.
Lordships.
I am incompetent. My senior must argue. Your submission was not fair.
I'm sorry, Your Lordships.
How long you are in practice?
Your Lordships, I took my license on October, October last year. Your
October. That you could have said, I am a very new counsel. I may not be able to argue this matter. We will adjourn this matter provided you will argue on the next date.
As a Lordship, my direct.
Build courage. Okay. I have
Lordship.
consultation with your senior. Written note to the Sarichanti.
Again.
We give you how much time you want. 1 week will be sufficient.
As a Lordship.
Next Friday.
Your Lordship.
Hela, upon nije argue karibe.
Your Lordship.
De do. Yes, had the learned counsel, young counsel arguing in the matter. Upon na kon?
Shamsundar Tripathi.
Huh?
Shamsundar Tripathi.
Shamsundar Tripathi. Young counsel Sri Shamsundar Tripathi 6 times on the premises of his senior counsel request to argue the matter. This court observed, though adjourn the matter, but intend to hear the counsel Sri Shamsundar Tripathi on merit involving the case. Matter is adjourned only on this ground to next Monday. Written note of submission with citation filed herein be kept on record. Hela, ID Act पढ़िबे पढ़िकरी आसंतु आमे धीरे सुरे जिबा हला
Oblige, Your Lordship.
experience. Any
Your lordship, in this matter, interim order to continue.
interim order achi?
Ag-
Okay, interim order to continue.
Grateful to your lordship.
If necessary, you can ask your senior to sit by your side. Hala, ha. Next.
Item 11,
Yes, 11. Anybody for petitioner?
Milord, I am for the petitioner, Milord, I may be permitted to
Yeah.
submit here. But I have filed a small date chart that is available with your lordship.
List of events.
List of events. Milord, it may not be necessary, it's a lengthy one, 3-page, but a very short point is involved. That the petitioner. It's
Now,
a
first,
legal
first make
question.
it clear, what is your challenge here?
Milord, challenge, I am challenging the order of the ombudsman under this grievance redressal forum. That
You are
this-
consumer.
I am a consumer, Milord, it's a small scale unit. So the issue is with regard to the delayed payment surcharge and.
Just go slow, go slow. You are challenging ombudsman orders means you have already visited the GRF.
Lordship is correct.
GRF, then ombudsman.
Ombudsman.
GRF order is annexure.
Annexure, Milord, 4, Milord. Sorry, Milord, sorry, 10, Milord.
Annexure
10,
10.
10 at page 86.
Annexure 3. And the ombudsman order?
Ombudsman order is, Milord, 11 at page 91.
11. Or 10 টা কোন?
Milord, 10 is
If there was remand,
GRF. Milord, 10 is the GRF order.
so matter was remanded probably.
Matter has come to this court, Milord, on 4-5 occasions. Those orders I have annexed.
No, what is annexure 10 then? Let us see.
Milord, 10 is the GRF order. Milord, first they have to go before the
10
competent
is
authority.
GRF. 9.
Here. 9, Milord, 1 second. 9 is.
So it's a remand order.
Remand order. Your lordship is correct.
So therefore, and so there is fresh order of GRF.
Your lordship is correct.
So remand by annexure 9. Then GRF comes to pass a fresh order annexure 10.
10. Milord, that is being questioned in annexure 11 is the
Then
order.
ombudsman is annexure 11.
Lordship is correct. So that is the impugned order, Milord. Milord, Milord, it's a legal question that is also reflected in the order while issuing the notice. Milord, admittedly, there is a dispute. No bills are available for that period. The ledger is not available. They say, Milord, even if the GRF in its order gives that finding at page your lordship would find. At page your lordship may kindly turn to 80.
It was entertained only on the ground that the ombudsman has exceeded the
Jurisdiction. That's correct. Your lordship may kindly turn to regulation 6 of the, that is the sole question, Milord. But I want, Milord, let it, the conciliation should be the first effort. That is what the objective of this grievance redressal forum and the ombudsman regulation says. Lordship may kindly turn to only 3 regulations, pure legal question on which this case was admitted. Regulation 6, your lordship may kindly see. Only 3 regulations. OERC, Grievances Redressal Forum and Ombudsman Regulation 2004. Yes, you get it. That's functions of the ombudsman.
Odisha Electricity Regulatory Commission Grievances Redressal Forum and Ombudsman Regulation
Lordship is
2004.
correct. Lordship is correct. Milord, regulation 6. I think it is there, Milord. It has not gone much amendment. So it is there. I don't think. Regulation 6, Milord.
Regulation
Functions
4.
of the 6, Milord. 6.
Okay. Yes.
Milord, 1 clause 6. Sub-regulation 1. Clause 6, your lordship may kindly come to that. The ombudsman, let the full regulation I did not read. Where
Clause C, clause C.
C, Milord, clause C. The ombudsman shall in the first instance act as a conciliator and mediator in matters which are the subject matter of the representation filed. Milord, the whole effort is just to settle the dispute through conciliation and mediation. That is what the ombudsman's your lordship may then kindly turn to regulation 9. Promotion of settlement by agreement. As soon as it may be practicable to do, but Milord, I am on regulation 9. To do, but not later than 1 week from the date of the receipt of representation, the ombudsman shall serve a notice to the concerned officer of the licensee named in the representation along with a copy of the representation and endeavor to promote a settlement of the complaint by mutual agreement.
Then please read again 9.
9, Milord, sub-regulation 1. Regulation 9. Milord,
Yes,
that
as
is
soon
as soon as it may be practicable to do, but not later than 1 week from the date of the receipt of the representation, the ombudsman shall serve a notice to the concerned officer of the licensee named in the representation along with a copy of the representation and endeavor to promote a settlement of the complaint by mutual agreement between the consumer and the licensee. That has to be read conjointly with this clause C.
So
of
now come to the impugned order.
That is
to
correct.
find
Yes.
whether
Yes.
what is the observation of the ombudsman with regard to the settlement.
Yes, he goes to the full merit, Milord, the disputed, your lordship may kindly, one thing is clearly
whether
disputed.
he has crossed that issue at all or not.
No, Milord, there is no effort at all for reconciliation or for mutual consent.
Annexure 11 question.
Annexure 11. Dispute ledger is not available.
Annexure 11 is page 91.
Milord, page 89, just let me just show one thing. I'll go to that. I'll read out that. Your lordship may kindly come to only page 89, one observation.
89 is of?
89 of the GRF order. Milord, that is not in dispute. Yes. That the records are not available with the licensee. I mean, Milord, this opposite party number 1, who is the supplier.
Where are you reading?
Milord, I am reading para 2, Milord. It begins with the word regarding the prayer number 2.
Yes.
Regarding the prayer number 2, it is observed that the DPS claimed by the petitioner for refund adjustment of rupees 7,09,805 is not at all based on any fact. The opposite parties have submitted the detailed calculation sheet of the DPS for the period from June 2002 to September 2006, and the forum has also got through the revision statements and found that the DPS calculation made by the opposite parties are correct, and the petitioner is liable to pay rupees 59,000 is justified. As per the calculation numbers one show, the opposite party has admitted to revise the DPS and to reflect it in the monthly bill of 2015. But, Milord, this is very important. But unfortunately, the opposite party have not revised the said period of DPS within the month of July 2015 with a plea that the old ledger were not available with them, and they had asked the petitioner to provide the past bills after 3 years, That is on 24/10/2018. But they don't have the record with them, ledger with them. They call upon the petitioner to supply the old bill so that they will make the calculation. Those things, the onus is they shift to the consumer. Essentially what happens, now they raise a delayed payment demand of around 29 lakhs, notwithstanding the fact that they do not have the records available, ledger available with them. Where from this calculation they made, that is the strange part. So therefore, what I am objectively praying, let it be remitted back to the ombudsman to decide the matter amicably. If the parties come forward and furnish some records.
The next line is also important, Mr. Acharya, you have left that.
My lord.
Reading there.
Yes.
Please conclude the sentence.
The opposite have, after 3 years.
No, were not available with them.
Yes.
And then had asked the petitioner to provide past bills after 3 years.
3 years.
That is on.
Who is the forum feels? Your lordship, I am obliged.
Who is the forum?
Forum feels that it is the complete negligence of the opposite parties. Your lordship,
that you left.
I would have read the, yes. So negligence of the opposite parties for revising the bills. However, of late the opposite parties have recalculated. What is the basis of recalculation? That is the short point. If Lord, the forum gives a finding that there is no ledger, number one. So it is a negligence.
Now coming back to the
impugned order. So impugned order, what the Law and Ombudsman does, instead of resolving the dispute with reference to the consent, mutual consent and agreement of the parties, he goes to adjudicate it on merit and says that you pay this much, which is disputed, and the licensee itself is not aware of the basis, is not the 3-4 times he has come before your lordship. Every time the matter is remitted back. There is no effort for settlement.
So I think the ombudsman. Mr. Acharya, this destroys your case. Come to page 101, para 17.
101. After conciliation, all the parties present signed the said conciliation report. A copy of the meeting dated, that is its 15. That is pre this. It's a 2015. It's not, we are not, it is post, this bill is post that.
Pardon?
This is post 2015. The dispute here. The DPA.
Oh, it is 2000, post 2015.
Yes, yes.
When this institute.
That is the current bill. They have served this around 29 lakh.
That was history.
Yes.
That was history.
That is the history that he has discussed.
Okay, then para 18. Oh, he
discusses same
all on
that
the
is a
2015 conciliation.
Lordship is correct. So
Okay,
it's a phrase, what I humbly pray, I am not unwilling to pay their dues. Any consumer,
No, just make a clear statement. What happened to those bills? Could you be able to produce bills?
Those bills, 3 years bill, it is very difficult. Of 2006, they asked me in 2023 to produce. It is practically impossible.
Then what?
Neither the supply company.
Then what was your plea? Please read further.
Let there be an amicable settlement. Let the parties sit before the ombudsman, decide a negotiable amount is to be arrived at and paid. That's all.
Then,
the whole dispute can be resolved.
Mr. Acharya,
Yes.
before concluding, let us know what was your response. Could you be in a position to produce those bills?
I have to take instruction on that. I don't know whether he is having those bills or not. But what the record shows, that is the whole effort, the whole objective of this ombudsman system, mechanism is to arrive at a settlement with mutual consent of the parties so that the dispute is amicably resolved.
Come back to page
At
89 again.
89. Madam.
After he records that you are asked to produce bills on 24/10/18, 3 years bill.
Minor.
So then read, however, of late the opposite parties have recalculated the DPS and have communicated it to the petitioner by letter.
That is the dispute. That is the dispute.
Petitioner prays
Yes.
that it is not sustainable.
So that is
Parties are
exactly what
liable to
I
pay
challenge.
compensation as per the guaranteed standard so and so.
Yes.
Then he goes to the merit of the case to regret with it.
That's correct. No, he goes to decide it on merit, Miller, notwithstanding the fact that this.
Then what was the foundation? Neither they were having record nor you could.
Yes. So there has to be a settlement, Miller. Your lordship is correct. Neither of the parties suppose they have any record with regard to that. So, Milord, in that event, the ombudsman should step in, and the basic object of that mechanism, Milord, that institution is to settle the dispute, not to, Milord, perpetuate the litigation. The whole endeavor of the ombudsman
then what is
as a conciliator.
No, Mr. Acharya, again come back to 105.
Minor.
He refers to a conciliation again. Taking place in 2019.
Observation is disposed of a copy of the order dated, Milord, para, your lordship is reading 27, 28, Milord.
Para
Lordship is referring to just above 27.
27. Yes, Milord, Bhubaneswar, a reconciliation meeting was conducted
3 lines, a copy of the.
Yes.
Or before 5 lines even you can read, you start from as after 6 lines.
Let's yes, as per interim order dated.
As per interim order dated so and so.
Yes, in OERC case number 43 of 2019 passed by the Hon'Ble Odisha Electricity Regulatory Commission, a reconciliation meeting was conducted in the chamber of the in presence of the members for discussion of delay payment surcharge of the revised period for load reduction from so and so. Petitioner had agreed with calculation of DPS for the period of load reduction from 1/6 to 1/9/2006 during the reconciliation.
So therefore, there is a reconciliation.
That is with regard to this period, 2002 to 2006. There are several. This is DPS is one aspect. The energy charges is another aspect. Now, Milord, they have again raised a delayed payment surcharge of 29 lakhs. Milord, where from do they get it? Maybe these old bills, they are, Milord, gradually, Milord, passing on to the future demand. So therefore, this has become an accumulated demand. Whether that is inclusive of this, so that is the dispute, Milord. But I am objectively praying, let the ombudsman, Milord, fix your lordship, fix a date. Let the parties go and appear before the ombudsman. Let him, Milord, try to arrive at a amicable settlement.
But findings are against you. There is a conciliation already, Mr. Acharya.
That is after that I came before your lordship again. Your lordship may kindly look at the final order. Milord, you are 129 page, Milord. 120, Milord, it begins in 2022. There is a order. After that, I came here.
No, 100.
Milord, he is referring to all old orders, old proceedings. In the interim, when was it finally disposed of?
129.
Yes. Milord, 129. Milord, he came before this court. This was finally, the matter is taken up. This the very same order. Mr. Rai on council, this honorable court's order, WPC number 15717 of 2022. Mr. Rai on council enters appearance by filing Waklatnama on behalf of the executive engineer, which is taken on record. He prays for an adjournment.
That's an interim order. Is there any other?
Yes, that was disposed of. I am coming to that. That was disposed of.
That was disposed of?
Yes, Milord. All those cases are disposed of. So I have come, the last order, Justice Rath, last order. Which annexure? Milord, your lordship, these are last order. No, that has been disposed of also, Milord, to relegating the parties to go there. Your lordship may. 1 second, Milord. Your lordship would page 125. The same order continues. This is
100.
another writ petition. Page, Milord, 124, the order begins. 5th
124.
of March 2021. 5th of March 2021.
Anandantu Sunantu,
Milord.
there are so many read petitions. Bring a list of dates. List of dates, it will be confusing because you challenge only here annexure 11.
Annexure 11, Milord, actually that has been passed on
And
29th.
as recorded, Mr. Acharya, we can't go behind. Admission, purpose of admission is only that there is a dispute probably existing.
Milord.
The ombudsman decides the matter without entering into conciliation.
That's correct.
But the ombudsman order clearly discloses there was sometime in 2019 an order for conciliation.
Milord.
You participated in the conciliation in the year 2019.
Milord.
And you are a signatory to the conciliation. Therefore, what is the issue remain?
No, Milord, that is with regard to a certain period. Milord, the whole period, this bill is, Milord, the present bill, they have raised again, including that particular disputed demand, which they say that that has been settled.
No,
So,
then
Milord,
why
what
did
I am-
you, then
Milord,
why did you,
admittedly,
then Mr. Acharya, why did you not involve all these issues in the conciliation?
Milord, that is exactly what I am praying
And
now.
the
Your
where is the
lordship,
conciliation report? It can clarify whether all issues were taken or only hardly some issues are
No,
taken.
they have filed a short thing in the counter. I was just going through it.
That conciliation
Nothing is, there is
report
no
is there.
serious report. Yes, no, there is no serious. Your lordship may kindly look at, they have filed one document. That there he only says aggrieved consumer at page, Milord, running page 155. Their internal page is 5, Milord. Sorry, 13, Milord. Internal page 13 and running page 155 of the brief. The aggrieved consumer with his authorized representative is present. The opposite party is also present. I took steps for amicable settlement of the dispute between the parties through mediation.
Of the
and
dispute. So therefore, he is taking up all dispute.
Yes, no, Milord, all dispute means this is up to the, he say that this particular, I'm reading, Milord, your lordship, means just go through it. So I took steps for of all, no, this is all means, Milord, this is pre that. So there are several phases. So this particular disputed amount, Milord, which they supply licensee register now.
So demonstrate what were the disputes pending before the
While
DRA?
the opposite party, Milord, I'm coming to that. The consumer submitted, he is not able
No,
to.
before that, come to what were the disputes? Let us know.
Milord, your dispute, your lordship may kindly
Come to page 87. He must have recorded what are the issues.
Yes. Page 87, your lordship would gone through the petition. The petitioner is a large industrial consumer bearing consumer numbers. Milord, I am not a large industrial, it's a medium scale industry MSME unit. The present petition is filed by the in obedience with the order dated so which pronounces, as in the complaint petition, the petitioner prays as follows. It appears that GRF has not yet settled the dispute and during pendency of such proceeding before the GRF.
So
Now
where from we get the disputes?
Dispute is manifold. I was going through this. It can't be ascertained. It's really a dispute of very serious nature. I'm not. I'm not.
Where is that dispute?
Dispute I'm coming. They have, yes.
DRF also not discussing on that. He simply goes on narrating everything.
Yes.
And demand order, then this decision, but he is also not
Exactly
what are the dispute? So your GRF application at least,
that your lordship may GRF application. Your lordship may call it some other day. I will rather file a brief synopsis. That would be
hide in part. Okay then. Yes, hide in part. Place the matter day after tomorrow.
Next week, 15th or 16th.
Next Monday.
Next Monday. 10টা খন্ডে order High Court order
Mr. Acharya, you just point out in a short note, what was the core issue in the GRA? And also negotiate it with the conciliations undertaken.
My lord.
So that we can come to know what were the issues and what have been conciliated, what have been left.
My lord. Lord, I'll file.
And
a
looking to the provision 6 and 9,
My lord.
there is no classification or reclassification. What are the issues to be conciliated? It says dispute is to be conciliated.
Correct. my
So
lord.
if it is multiple dispute, it is to be conciliated.
Correct.
If it is individual issue, it is to be conciliated.
Correct. my lord.
So therefore, ଆମକୁ ଏଠି କିଛି ଆମେ trace ପାଉନା, ଆମେ ପାଉଛୁ କେବଳ ଏତିକି, there has been repeated conciliation process, you are party to or signatory to such conciliation process.
My lord. My lord.
So therefore, please specify.
But present
Lord,
disputed the present disputed amount is the brainchild. Sorry, present disputed amount is the brainchild of the petitioner itself in course of the litigations during the pendency of the.
So ଆଣନ୍ତୁ GRF application ଟା ଅନ୍ତତଃ ଆଣନ୍ତୁ।
Again.
GRF application ଟା ଆଣିଲେ ଜଣା ପଡିବ core issue ଟା କଣ ଅଛି।
You can also prepare a table.
କରନ୍ତୁ ଆପଣ।
What was his claim for what period and what was the conciliation, date of conciliation, and what was the amount arrived, and what is the ultimate direction of the, because ombudsman are also allowed many of his claims.
Yes.
You have not challenged that.
So therefore,
We are not challenging that.
You have not challenged GRF or ombudsman.
Ombudsman, yes.
So you simply prepare a table.
Only
you prepare a
DPS
table
amount.
that the X, Y, Z are the issues. X having been conciliated, Y, Z having been answered by the ombudsman in his favor, nothing survived. All right.
And since the learned senior counsel is saying about conciliation, amongst you, we can conciliate and file that also here.
But conciliation of he is not ready to come to the table of conciliation. He is
I am there. Why should
Now he has
I am
stated.
availing energy. Why should I not be prepared?
Now he has stated.
I saw the other day from the order sheet of the learned, out of 30, in spite of my Lord Justice B.N. Ratha had directed to
B.N. Ratha nୁହଁ ଏଠି କେହି judge
my Lord, this honorable court.
ନାଇଁ B.N. Ratha କହିବେନି.
Sorry, my Lord.
Biswanath is how many words?
Sorry, my Lord.
Biswanath is how many words? So where from BN comes? Justice B. Ratha, you may say.
Because he writes Devaranjan 2 words. DR.
That is 2 words.
1 word. Devaranjan is 1 word.
But Biswanath, Jagannath, these are all, Vaidanath, these are all 1 word.
My Lord, your Lordship.
Devaranjan is also 1 word. D. What you are writing DR?
No, my Lord. I have objected to this honorable court sometimes, but
Not this court, the registry. Why this court?
In a lighter way.
my Lord.
So BN Ratha is never called. My registry is also committing that mistake. Invitations are coming. Justice BN Ratha.
Your Lordship in the case had directed to dispose the representative within 4 months, but he has taken 3 years. And out of 30 order proceedings, he has taken 18 days.
Why you accommodated 18 days and 3
He
years?
has nothing to big boy ombudsman.
The ombudsman भी काहे इतने दिन रखिबो? यदि cooperate न कला reject कर दो.
Again, he will come to we want to settle the matter for all the time to come. But
Can
he
you
wants
do
to
that?
linger the matter.
That's exactly what I have also advised the client, not that I am also, I don't believe in this multiple litigations. But I personally also am against all those multiple proceedings. So let the parties settle it. He ultimately take a agreement.
Provided there is something left to be settled.
No, not many things. They have raised a huge
table
amount of
ଆଣନ୍ତୁ
29 lakhs.
କଣ dispute ଥିଲା କଣ settle ହେଇଛି କଣ ସେ decision ନେଲେ.
Otherwise, this
And Mr. Acharya, you must have marked what fell from my lord, that if there is a conciliation, you can't direct for reconciliation
No,
or
that is true.
reconciliation.
Yes.
And now
But
at
if
least
that
by reading through whatever you have placed, we have found 2 conciliations. And that annexure 11 is result of that conciliation. In fact, you are challenging annexure 11. Please also take note of that.
But I'll go through the.
Yes, please prepare that table so that
Yes.
it will be clear.
present case is also covered by the judgment rendered today in item number 1. That is a concurrent finding of the
To conquer.
Yes, ma'am.
So that is working in your favor. The way it started, the other matter also, that NESCO matter.
Mr. Nandi, prepare ହେଲେ criminal appeal. ପୁରା ready. ଆଉ କାଲି ପରଦିନ ପଡିବ case. Rest of the
Madam,
cases.
item 12, your lordship, we have filed an affidavit which has been sworn by the IIC Sundargarh. But the two of the appellants which we have died, we have brought that on record, your lordship.
Two of the appellants in respective cases.
In respective, my lord.
Have died.
One each. Both of them have expired. Your lordship had directed to bring that on an affidavit, your lordship.
Right. So therefore,
So
appeal.
one affidavit or two affidavits in two cases?
One affidavit only we have filed, your lordship.
One affidavit, but two different cases. You file
Different-
copies with a memo
My lord.
Yeah,
so that
you
it can be taken note of.
You adopt that affidavit
by
in
filing.
the other case.
Lordship.
So
But
that's because, and we don't close because ultimately in the judgment we will be dealing that.
My lords.
By even dismissing appeal in part, we are not relieved from the case. Ultimately, a judgment has to be given. Therefore, we'll keep it on record. You have already filed.
Well, I have already filed.
Okay.
Item.
It has been reflected in the list.
Continue করছি তো একটা পেন
মানে যায়নি ফেরি কি?
No, that has not been reflected. Your
Yes.
lordship.
Yes, sir.
It has not been reflected in the list.
Yes, sir. And as an indication of. Okay.
Item 15, my lord. I was also ready in that appeal, jail criminal appeal 23 of 2005, my lord.
Item 50.
15.
15.
Yes, ma'am.
Ready upon.
Yes, ma'am.
Suniba?
Yes, ma'am. But what happened, my lord, last occasion I was held up in another court that therefore that matter was allotted to some other.
କଣ କହ ପିଟିସନ ଫାଇଲ କରିଛନ୍ତି ରିକଲିଂ ଦ୍ୟାଟ୍ ଅର୍ଡର ନା ଆମେ ଆଡଭାଇସ କରିବୁ
ସେ
ଲାଇଭ ଷ୍ଟ୍ରିମିଂ ହଉଛି you should be careful steps ଆପଣ ନେବେ ନା ଆଉ କୋର୍ଟ କୁ କହିବେ ଆଜ୍ଞା ମୁଁ ନଥିଲି ଆପଣ ଏହା ଲେଖିଦେଲେ ଆରେ ଆପଣ ନଥିଲେ ଆମେ ଲିଖିଦେଲୁ ଆମର ଭୁଲ କଣ ଅଛି
JCRL
if you have a bona fide reason bring application.
It is JCRL engaged by this court.
No, that part we are now stating. Can it be brought on record without being part of the record? So you have to state that in affidavit, maybe by your clerk or by yourself. Actually, you may not file, but you have to bring those facts on record. That I was not available, and it is not that it happened once. Several adjournments for weeks together. That after that it was.
I was absent in one day, madam.
No, you have not realized.
Give us
It is almost called every day. This list is being called every day. Realize how the court is functioning.
There, madam.
Then how could you miss it then? If it is called every day, you ask him whether he's calling or not.
No room for oral submission.
Obligatory.
You know that very well.
এটা কাজমেন্ট আছে গোটা
Read petition suffers from merit so far as retention of some deposit by the petitioners made during the test was undertaken and lying with OP number 1. On dismissal of read petition, it will now be open to OP number 1 to deal with the same in accordance with law and by completing such exercise within 1 month from the date of communication of this judgment by either side. The read petition does stand dismissed, but in these circumstances, there is, however, no order as to cost. Mr. Swai, Mr. Swai, have you checked your cost title in the REIT application? Just be on my. There is a serious error in continuing with the litigation. Earlier, it was filed by the farm.
Yes, madam.
Okay. Now, subsequently, you brought substitution.
Madam.
And farm is no more there. Farm is no more there. XY, as the legal heirs of the owner of the or the proprietor of the farm have come.
Madam.
So, how could you commit such dangerous mistake? Maybe you are not there. I don't blame you. I blame the petitioner's counsel.
No.
You are a subsequent counsel, third set of counsel probably
Yes,
in the REIT application.
Yes.
Please go through and find the cost title. On merit also. So that is also a serious flaw. I could have dismissed on that itself. Maybe somehow that has.
I have filed a memo.
43 ମୁଁ ତ କହିଦେଇଛି ମତେ ଏଭଳି disturb କରିବେନି ଆପଣ slip ଦେଇଦେବେ ପଳେଇବେ
ଦେଇଛି
ହଁ ପଳାନ୍ତୁ ଆପଣ ପଳାନ୍ତୁ
item 2 item 2
contempt application, my lord, order dated 4/10/21.
1 minute. Yes, this is this fast contempt?
My lord.
Fast contempt disposed of. Yeah.
Lord, I may be permitted to write the name of the contemner.
Okay. All right. On oral submission, counsel for the petitioner is permitted to bring the correct name of the contemner by making necessary endorsement in court. They filed it. Yes.
Item number 3.
Dismissal restoration. Funeral
It was dismissed at the stage of fresh admission.
Again.
What happened? Why did you not turn?
One of my family experts, that's why I have to ask for the funeral, native place for funeral.
Who expired on that day?
One my brother of my grandfather.
Relation?
Yes.
Okay, so this court had this
unfortunately
council. Also involved the state council. Considering the submission and the ground stated, this court find there is genuine ground of non-appearance. As a consequence, this court allows the CM appeal, thereby restoring the REIT application. What is the REIT petition?
Well, REIT petition, I am...
Please be on mine.
Since 2012, I am being harassed by continuously by the revenue authority. Everything, your lordship, I have discussed. What happened, my lord? In 1992 and 1995, two family settlement made. The impact of the London Tahsildar, the main first point, he is not agree with the Supreme Court judgment. His judgment says, the London Tahsildar judgment, I am not, this judgment is not binding.
How can there be a writ of mandamus to this nature? Please read your prayer. Please read your prayer. Can there be a mandamus possible?
No.
Yes, you seek a mandamus to the Tahsildar to record first son, Sharat Kumar Shastri, and fourth son, Samanta Somanatha Sastri has the family partition agreement. How can there be a mandamus?
My review.
Please withdraw, because nowadays there is live streaming. We will not talk much. Sorry, I said it is not maintained.
Why I have, because my reminder and review petition pending, and in the
Sorry.
said order, many
Sorry.
mistakes are there.
Find out your options. Find out your options.
No, my
At
lord,
the submission of
my
the
lord,
council.
kindly one minute. I have come with a prayer. Cannot stop my I am continuously harassed by the revenue authority since
Find out the
2012.
recourse.
A course I mutation appeal.
Writ of mandamus is not possible. Sorry. I'll not waste my time. Yes. At the submission of land counsel for the petitioner, read petition.
Review petition time, man. You have should only my review petition pending that may be disposable.
And a prayer, and the prayer involved herein, this court find there is no scope of issuing mandamus looking to the desire of the petitioner herein. In the circumstance, the read petition is not sustainable.
Direction of the authority,
Petition though dismissed, there shall be no debarring to the petitioner in finding other courses, if any, available to him.
Review disposal policy.
Yes.
Review for pending disposal.
Sorry. Jota suno to amo pakhare hei paribol jota am kahi dabi.
Item 4.
Mandamus issue karibu. Yes, agreement is, if there is mistake, then go challenge agreement. Yes, next.
Item 4.
Non-appeals for the petitioner when the matter is for dismissed for non-prosecution.
Item 5.
May I please, your lordship? The petitioner challenging the order dated.
Mic on.
The petitioner challenging order dated 10/2/2023, Annexure 6, your lordship.
Date fate would have
Lordship,
the petition your challenge, come directly.
Lordship, petitioner, the petitioner is the written candidate, your lordship. The opposite party number 1 file an election petition challenging the election of the petitioner, your
That's
lordship.
right.
In that petition, he has taken a ground that he has approached the collector under section 25, your lordship, or 25(1)(3), but not doesn't whisper anything regarding what the date that proceeding has been ended.
Merit of the election dispute.
Yes, your lordship. In
So
that case, I
file
file a petition for order 14 rule 2 to decide the issue preliminarily, your lordship.
No. Election dispute preliminary issue.
My respectable submission, your lordship.
These issues cannot be decided preliminary.
Once he has taken a plea before he has approached the authority under section 25(1)(3).
Question will be kept open. And it will be decided together along with other issues. See, it will be upon you are a written candidate.
Yes, your
therefore,
lordship.
there will be obvious reason of deferring the matter. So don't adopt these procedures. If you have a ground, you may ultimately succeed. Why are you delaying the proceeding?
No, my respectful submission is that
targeting.
Knowledge how it along with other issues decide.
Yes, absolutely. Yes, in the course of submission, land counsel for the petitioner doesn't want to press the application. However, request this court for observing for keeping the issue involved in the interim application open to be adjudicated along with other issues in the trial of the election dispute. Okay, this court find this is a genuine request. Rejection of a request for undertaking preliminary exercise to take out the election dispute cannot stand on the way of the written candidate to pursue such remedy even in the ultimate trial of the election dispute. In this circumstance, this court permit withdrawal of the writ application, but however, keeping the issue involved herein open to be adjudicated along with other issues. And in the event, provided the written candidate brings such issue in the draft issues. And in the event such issue is brought, there shall be a decision independent of the observations made in the impugned order.
Item 6.
May I plead, your lordship?
The
Revenue
petitioner,
miss case is still pending.
pardon, your lordship,
Revenue miss case is still pending.
still pending, your lordship. The petitioner belongs to SC category, your lordship. He applied under 22 of OLR Act for permission to the authority
कौन
to
आपण पूरा targeting चाहते review miss case.
target.
argument
Your lordship, till then, your lordship, till disposal of that this revenue miss case,
no
your
entry
lordship,
order possible. Sorry.
because your lordship, the petitioner's son, he has opened a grocery shop, taking loan from the authority, your lordship. Due to COVID, as he could not repay the loan amount, all his property attached. This property is
आपनको section 22 pending ଅଛି तो grant of permission.
Yes, your lordship.
What interim order you want at this stage?
Because your lordship, one hand, the authority is not providing permission to sell this land and repay the loan amount standing in the name of the petitioner, your lordship.
ସେଥିରେ revenue authority ର କଣ issue ଅଛି?
Collector
ଆରେ ଆପଣ loan ନେଇଛନ୍ତି ଆପଣ ସେ କଥା ବୁଝିବେ ତାଙ୍କ କଥା ସେଠି ବୁଝା ହବ।
ଏଇ property ଟା
ଆପଣ
ବିକ୍ରି କଲେ
permission ପାଇଁ ଯାଇଛନ୍ତି he will decide whether permission can be granted or not.
oblige, your lordship. ଏଇ property ଟା ବିକ୍ରି କଲେ, your lordship, he will repay his loan and ତା ଘର ବାଡି ଯୋଉଟା mortgage ପଡିଛି।
ତାହେଲେ କଣ recourse କଣ? ଯେତେ ଶୀଘ୍ର ସାରି ଦେଇ ପାରିବେ ସେ
Yes, your lordship.
ଆଉ ଏତେ argument କରୁଛନ୍ତି। ମୁଁ order ଡାକି ସାରନ୍ତିଣି।
Till then I may be protected.
At the submission of counsel for the petitioner. On the premises that petitioner has a loan outstanding involving the disputed land, is in urgent need of decision in the revenue miss case 404 of 22. Keeping this in view, this court disposes the application, the writ application simply observing there should be expeditious disposal of the revenue miss case 404 of 22. Involvement of the involvement of the party likely to be affected at least within a period of 2 months from the date of communication of the order.
Till then no course by OP4. Till then no course by OP2. Collector has initiated a 14 surface proceeding.
Pardon, Subudi.
Collector, because the bank has initiated section 14 of surface proceeding.
That can't be such an issue decided here. Sorry. Find out other options available.
Item 7.
7.
Bank loan ବିଷୟରେ ଆପଣଙ୍କର ଅଲଗା କୋର୍ଟ କୁ ଯିବ। ମତେ ଯଦି revenue case disposal expedition ଚାହିଁବେ ତାହେଲେ ମୋ କୋର୍ଟରେ ରହିବ। ଦିଟା ଯାକ ଯଦି ଜଣେ decide କରିବ ତାହେଲେ chief କୁ mention କରିବେ ଆଜ୍ଞା ଦିଟା ଯାକ assignment ଯାହାକୁ ଦେବେ ଗୋଟେ କାହାକୁ ଦେଇ ଦିଅନ୍ତୁ। You can't club up both these issues. And at the same time, you can bring another writ application on the other issue. Since my RMC is still pending, I should be protected. But that's not my jurisdiction. जानतु बहुत कथा माने बहुत देई सारलेनी हला आपण बुझिथा जदि थिबे ताले उपयुक्त पदक्षेप नियंतु नेक्स्ट
affidavit टा फाइल हेई जाई कॉपी टा दे दो
affidavit फाइल करछोंदी
नै हेई जाई ऑलरेडी ई फाइलिंग हेई जाई 5/5 रे
तबे 5/5 है State Council, Sri Contact, and that is that there is already filing of affidavit on 5/5, which is not on record. Copy?
De do, aji de di.
Okay, copy of the affidavit has also not been served on the learned counsel for the petitioner. List this matter on Friday, along with the affidavit, if any, filed in the meantime.
Copy, sir.
Item 8.
Yes. कौन है मिस्टर महापात्र कौन आपण ठेली आगु को आसुचंती
Lord, I want to say that item number 48, which I have not mentioned before,
व्यस्त
to
काहे
be taken up today.
मते अलाउ करन आपण तो एटी गोटे मिनिट मोर नष्ट कर देले
Second. Oh, like,
मु सेतोलटू देखुची से धसई आगु को आसिया को चेष्टा करछु
sorry, my lord.
मु से जाय गले तो सुनो पार्टर जदि ओल्ड मैटर अछि ओल्ड मैटर आगे डाकी दबो ओल्ड मैटर परे पार्टर डोडा को डाकी दबो यस
Here, my lords, if what happened, my lords, the original record of right, my lords, that is a Puratana Patita. in hall settlement that has been settled the Gadia.
ଯାଇଥିଲା state council କୁ direction ଦିଆ ହେଇଥିଲା what happened?
ସେଥିରେ ନାହିଁ ସେଥିରେ ଏଇଟାରେ ମୁଁ ମତେ ମିସକେ କହିଥିଲା ଯେ commissioner has passed that order but that order is not final order. They said that it is remanded to Tahsildar. But my humble contention, the commissioner in the first paragraph observed that yes, this is the position, but remanding is not necessary. They could have concluded this. That is what I filed a petition for amendment.
Amendment.
Amendment. That amendment should be allowed. I also.
Is this put a miscase kind?
Yes,
Oh, it. Okay, the IA 6721 of 23 is an application to bring amendment to the writ application. Can amended cause writ petition?
Already I filed there because unless and until it is.
Day after tomorrow, aniba?
Day after.
No, amended writ.
No, now the law, the procedure is now unless and until amendment is allowed, amendment petition cannot be filed because it cannot be scanned. That is, office cannot be.
Okay, let the amended writ petition be filed.
Already filed,
stated to have been filed already, be brought on record.
Yes.
Matter be listed on day after tomorrow. ସେଇଟା ହେଲେ କଣ ହବ କି ମୋ ଜଜମେଣ୍ଟ କଭର କୁ ଆସିବ
କଭର କରିଛି
କପି ଦେଇ ଦେଇଛନ୍ତି ତାକୁ
ହଁ
ଡେ ଆଫ୍ଟର ଟୁମରୋ
ବାହାରକୁ କ୍ଲିୟର କରିଦଉଛୁ ଆଜିକାଲି ଯେହେତୁ ଲାଇଭ ଷ୍ଟ୍ରିମିଂ ହେଲାଣି ଆମେ ଆଉ ପାଠ ବିଷୟରେ ବେଶୀ ଚର୍ଚ୍ଚା କରିବୁନି
ପୁଣି ରେକର୍ଡ ହେଇକି ସେଥିରେ ରହିବ
ହେଲା ତେଣୁ ଆମେ
appropriate forum
item 9 ଟା କରିଦିଅ Mr. Manoj Mahanti, number 2, 6, withdrawal of the writ application with liberty to bring better application.
File appropriate forum.
Okay, to bring application before competent authority.
Competent.
Okay, with this liberty, the petition stand disposed. हम भी जल्दी सारी परिबु केस एंटी
हाँ हाँ
mention from the list.
No, my Lords. Petition is the return candidate. Return candidate, the petitioner engaged one counsel and who has filed the no instruction memo without any instruction from the client.
Pardon?
The defendant, the return candidate engaged one counsel and the counsel while conducting this case filed one no instruction memo without instruction, getting instruction from the client. Then the notice was issued, the petitioner appeared and filed one application for satisfied the expired order. And the expired order was satisfied with cost. And I have paid the cost and directed to file the doubles within 3 days. I have complied the order.
You are the return candidate.
Yes, ma'am. I have complied the order. And thereafter, Lord, I have filed doubles along with a counter claim. Those.
Item 9
Those. And while hearing on the counterclaim petition, is a
counterclaim petition.
Yes, Lord.
Where is the counterclaim?
I have filed double S along with counterclaim.
Where is the election dispute counterclaim question asila kote?
Yes, Lord. Say he has prayed in the election petition, and while the
there is no room for counterclaim in election dispute.
And there is a judgment of this honorable court.
Yeah. I don't go by those judgments.
Yes, sir. Then,
sorry, there is fundamental.
Yes. Then, my lord,
It's not a civil.
Yes, no, no, what
dispute.
happened, my lord?
Right title interest so
Yes,
that
yes,
somebody can put forth a claim.
While hearing this claim, counterclaim
You may
petition.
bring a,
No, no,
you may
no, my
bring a
lord,
written
yes,
statement
yes,
questioning anything that may be
Yes,
issued.
yes,
at
yes, my lord. What happened, my lord, in the impugned order, while rejected the counterclaim, rejected also my double S. That is my case, my lord.
So where is the decision of accepting a counterclaim in election dispute?
Not recent, my lord, but
And absurd proposition. It's an absurd proposition.
the amended, my lord,
Amendment written statement cannot be coupled with or treated alike counterclaim.
for inclusion of her counterclaim. For inclusion of her counterclaim in the light of observation.
What do you claim in a counterclaim in an election dispute?
But he doesn't know writing the Odia.
Was that the subject in the election dispute?
No, no, no. While
election dispute is contesting your election.
Yes, my lord. The second prayer is he wants to be elected, my lord.
Sorry, this is simply to be thrown out.
No, no. But doubless, my lordship, my doubless.
Forget that.
No, no,
Come to your rejection of your doubless.
Yes, my lord. My doubless has been rejected, my lord. First allowed and then rejected, my lord.
When you are set ex parte, by which order?
Ex parte page 59, my lord.
Read that order.
On 1/2/2023, on council for the person present, SR of the open or break with an endorsement by process server that open number 1 has gone to Bhubaneswar has stated by village entries and the copy of the summon was affixed on the wall of the house of the open number 1. Prior to this, as many as the 3 notices were issued in both ways, which were back without service with an endorsement, and in the absence of open number 1, their family member refused to receive the court notice and peruse the case record. The open number 1 is the working serpent.
So notice found to be sufficient. So you are declared ex parte.
Yes, my lord.
Then what happened?
And my lord, at page 62, my lord.
Then when your position was restored, page 63.
Yes, my lord. Page 63, my lord.
63. Yes.
63, second paragraph. Considering the submission of both the parties, Bhaklatnama filed on behalf of the open number 1 hereby accepted, and a petition under 9 and Rule 6(7) CPC is allowed for the interest of justice subject to payment of cost 500 rupees with the direction to the file doubles if any within 3 days and adduce all evidences if any on our behalf at the earliest. On the 18/3/2023, counsel for both the parties are present. Counsel for the open number 1 paid the cost imposed on her and memo executed on that effect is filed. Open number 1 filed her doubles along with the counterclaim. Copy served on the counsel for the petitioner. In the put up on 23 for office note of the counterclaim. 2023, the counsel for the both the parties present. Office note to the counterclaim not yet ready. Prepare.
Where do you find your written statement has been rejected?
My lordship, the 69, my lord. The so cause,
yes,
and the counterclaim already filed by open number 1 not accepted.
Sorry, what written statement rejected?
Yes, my lord. First allowed And without that order has not.
portion padhantu.
Yes, my lord. Page 68 last paragraph, my lord.
Yes.
There being no doubles filed in this election petition by OP number 1. The counterclaim was obviously not set up in the doubles. After careful scrutiny of all the materials on record, as well as analyzing the
Where is your written statement? Dekhele.
annex of
15(3) order pore apna written statement file kale. Where is that?
my lord, page 36, my lord.
So you filed a composite. You filed a composite.
No, my lord.
Yes, you filed doubles along with counterclaim. That is
Yes,
one application. So there is no independent.
Counterclaim, my lordship, first page 36 to 38. That is the counter doubles, and the counterclaim is the page 39 to page 41, my lord. Page 40, 42.
It is one composite application.
Along with, my lord.
So how can that be? How can that be?
Well, counterclaim
can't.
Counterclaim be rejected, but doubles cannot be, my lord.
There is no doubles in the eye of law.
No, he has accepted and he has directed to file. I have complied and cost has been paid, my lord.
This can't be treated as a written statement. Again, upon written statement file korikiri.
Yes,
ta sange ro counterclaim koleni.
Korichu baita.
ମୁଁ ଆଜ୍ଞା ଏଇଟା ଲାଇଭ ଷ୍ଟ୍ରିମ୍ ହଉଛି ତେଣୁ ଆପଣଙ୍କୁ ଆଉ ବୁଝେଇ ପାରିବିନି ମୁଁ ଆପଣ ଯଦି ସେୟା ବୁଝୁଛନ୍ତି ଆଉ at the submission of learned counsel for the petitioner undisputedly and this order involved the rejection of so and so. Yes, rejection order dated (3/4/23) passed in election petition number 1 of 2022. Considering the submission of the counsel that he has filed counter affidavit as a written statement, apart from filing of a counterclaim, this court on perusal of the order sheet from order date 15/3 that is 15/3
2023, page 62.
2022.
23, my lord.
Sorry, 23.
Yes, my lord.
Page.
Page 62, my lord.
62.
62, my lord. At page 63, the order is there.
Page 63.
Page 63, second paragraph.
Just 1 minute. Yes, 63, 15/3/23. (62) and 63 finds the election tribunal in consideration of the request of the written candidate allowing the application at the instance of the written candidate, permitted the written candidate to bring a written statement, if any, within 3 days, however, subject to payment of cost of rupees 500. Further attachment of condition in the event of compliance of the order, the written candidate shall also be permitted to adduce evidence on our behalf. Case was next posted to 18/3/23. On 18/3/23, the written candidate brought doubles along with a counterclaim. It is here on perusal of the Annexure 3, this could find on 18/3, the written candidate appears to have filed a written statement along with counterclaim in one composite petition. Considering the dispute is an election dispute, even assuming the counterclaim at the instance of the petition, the written candidate was not entertainable, at least the written statement of the written candidate should have been maintained. Okay, this court therefore find a case required to be considered. Direct issuing notice. What is the position of the dispute now?
Now, my lord, the petitioner's witnesses have been recalled and examined and cross-examined. Now the
But your written statement would not have been considered.
no, my lord, that is my case, ma'am.
You are participating in the cross-examination.
Yes, ma'am. No. First, I have not participated because the earlier council filed the no instruction memo. That's why that was recalled and examined and cross-examined. I have
If a
participated.
written statement is declined,
Yes, ma'am.
you have the right to cross-examination to the extent plaintiff pleading,
Yes. I have cross-examined, my lord. But my lordship,
Okay, evidence, okay, this could direct stay of the further proceeding in election petition 1/22 till next stage. Well, requisites as undertaken be filed by day after tomorrow. Registry directed to issue notice fixing short returnable date. Matter may be placed immediately after vacation with report on the service of notice on the opposite party number. Private opposite party ke return a deputed candidate keta OP.
yes, my lord, election petitioner is there.
OP number
OP number 1 and 2.
1.
2 private parties, my lord.
मैंने किए रिटर्न
Prabhasini
इलेक्शन
Khotwa.
पिटिशनर किए
Election petitioner Prabhasini Khotwa, OP number 1, my lord.
1
Yes,
टू कौन पे पार्टी है
2 is contested, but is expected.
so it's a performer
Yes, ma'am.
तार एथे रोल कौन ଅଛି
Again.
OP number 1 ହେଲା yes. Examine this aspect.
Yes, ma'am. Yes, ma'am.
The single bench holding
Yes, ma'am.
counterclaim permissible,
Yes, ma'am.
he has diluted the provision.
Yes.
That may be permissible in a civil suit,
Yes, ma'am.
but not in a election dispute. Election dispute, what the Gram Panchayat Act section 37 says? Section 37 says the procedures in the trying of a suit shall be followed by the tribunal.
Yes, ma'am.
Procedure doesn't mean the entire CPC.
So that part has been.
Procedure means
Yes, ma'am.
the procedure in issuing notice,
Yes, ma'am.
procedure in calling for witnesses, calling for records, recording evidence,
Yes, ma'am.
marking exhibits. These are procedures.
Yes.
Rest are statutory provisions.
Yes.
So, yes, unnecessarily, nahi background nahi, civil case or background nahi, decision ja pehle cha de debe.
No, no, ସେଇଥିରେ ସେଇ ଜିନିଷ ଗୁଡା
କିନ୍ତୁ ଆପଣ decision ଆଣନ୍ତୁ
ଆଜ୍ଞା
Suppose somebody files, can normally written statement along with counterclaim file ହେଇଯାଏ.
Okay.
Normally civil suit ରେ ସେଟା ହୁଏ. କିନ୍ତୁ suppose ଜଣେ file କରିଦେଲା inadvertently ଦିଟା ଯାକ composite କରିକି file କରିଛି. ତାହେଲେ at least he could have rejected the counterclaim part.
Yes, sir.
He could have sustained, he could
Yes,
have maintained
yes,
the written statement. ତା ଉପରେ decision ଆଣ.
Okay.
It should not have been rejected in entirety.
Yes.
Yes.
Item 11.
Petitioner is challenging the order of the sub-collector Jagatsinghpur, my lord. The order sub-collector is allow the mutation appeal and cancel the direction for the
It's a
cancel.
order in mutation appeal.
My lord, mutational appeal is allowed and cancel direction for cancel the RR. After delay of the 11 years, delay is
Who
there.
are you the mutation applicant?
No, my lord. Appeal number 5.
ଓହୋ ପୁଣି ସେଇ କଥାକୁ ଯିବ ଆଉ କଣ କରିବା ଲାଇଭ ଷ୍ଟ୍ରିମିଂ ବନ୍ଦ କରିଦବା ତାହେଲେ ଆଉ ଆପଣ ମ୍ୟୁଟେସନ ଆପ୍ଲିକାଣ୍ଟ ନା ଆପଣ ଅପୋଜିଟ ପାର୍ଟି
Opposite party.
ମ୍ୟୁଟେସନ ଆପ୍ଲିକେସନ ରେ ୟୁ ଆର ଦି ଅପୋଜିଟ ପାର୍ଟି
My lord. I'm a
ମ୍ୟୁଟେସନ ଆପ୍ଲିକେସନ ଦେଖେଇଲେ ଆଟଲିଷ୍ଟ ତା ଅର୍ଡର ଟା ଦେଖାନ୍ତୁ ମ୍ୟୁଟେସନ କେସ ର
mutation order was page number 10.
ପେଜ ନମ୍ବର
10. 10
10.
and 10 and 11. Both.
No, 10-11 is the appeal order. I am asking you mutation order. File करनाहांती करचंती केते अछि
Page number 30. Good time.
Where is that?
My lord, one minute. My lord, consultor plan annexure 6.
Annexure
Sorry, my lord, sir, देखिए.
एक साथ ऑर्डर ना नहीं एक साथ ऑर्डर देना
केम जणा पड़िबो आपण अपोजिट पार्टी थिले कि पिटिशनर थिले केम जणा पड़िबो
Opposite party थिले तो लिखा है. Opposite party में civil suit is pending.
ओ सॉरी सिविल सूट जदि पेंडिंग अछि कहि दोछि जा आउटकम हबो सब्जेक्ट टू रिजल्ट
Lordship.
देन ठीक अछि. In the course of submission, learned counsel for the petitioner brought to the notice of the court that involving the self-same property, there is pendency of a civil suit. Case number civil suit 78/2013.
My lord, 78 of 2013.
78 of 2013 before Civil Judge Junior Division Jagatsinghpur. This court thus find any development in the mutation appeal number 34 of 2015 shall ultimately be abided in the judgment and decree involving such suit. With this observation, the requisition stand disposed of that. I'll call it a document would have a consensus to.
Item 12, the Lordship may kindly recollect on Friday, it was before your Lordship. I am challenging the order passed in the mutation appeal on the ground that
You challenge what order?
Annexure 5 at page, my lord, 50. Page 50, my
In mutation appeal.
yes, my specific case before your Lordship is that I have not been given an opportunity of hearing. It was filed on the mutation appeal was filed on 1/11/2021 and it was disposed of on 26/11/2021. The Lordship may kindly see.
You are not a party there.
I am the applicant. I am the applicant.
You are the appellant.
I am the
Then-
applicant without anything, without hearing me, without giving any opportunity to any party. This case has been disposed of. Your Lordship may kindly turn to page 56. Last but one para. For the aforesaid reason, I have already held that the matter in dispute involves serious disputed
Here also a civil suit pending.
two
Three civil suits. Two civil suits are pending.
In spite of it, ROR was issued in favor of the opposite parties and taking advantage of it, they are selling away the property.
Well, I am appearing on behalf of the opposite part number 4 to 11. May let's see. In the earlier mutation proceeding, the ROR was issued, and that mutation proceeding was not the subject matter of challenge. They have filed a fresh mutation application, which was dismissed. And after 2 years, Your Lordship, the mutation appeal has been
Madam,
filed.
since a civil suit is pending, ultimately it will be debated.
That is fine. I am not, that is true. But question is, by taking advantage of that ROR, they are selling away the property.
Go and file an injunction in the civil suit.
2 civil suits, Your Lordship.
Go, Mr. Counsel. Please
Sorry.
take your seat.
Madam.
Please take your seat. Ajikali live hochi mu apun konte koi bhi seat loko apna mahokilo kharab bhabibo. Please take your seat.
My lord, your lordship, in the final.
So therefore, if a civil suit is pending or 2 civil suits are pending, go and get an injunction.
My lord, I have advised them accordingly. But question is, my lord, for the time being, at least I may be protected.
No, no.
I am.
No, that will prevail over the mind of the civil judge, madam.
My lord, question is, my lord, your lordship may kindly turn to at this stage. I have annexed the page 33, your lordship may kindly. Page 33. In the final decree
Page
proceeding, 3, my lord, they have filed a suit without making us party, although we are the legal heirs of the original.
That's right. Therefore, you must have brought a suit to declare that the suit.
We have already, prior to it, we have filed a suit for partition.
Madam, not possible to grant
your
an
lordship,
interim order.
kindly turn to page 33.
Yes, I am there.
In spite of, in the final decree proceeding, I have been made party. And they are not taking any step.
Is it a suit for partition?
One is for suit for partition that is filed by me in 2016. Thereafter, by misrepresenting that he is the foster son of that person, he has his legal heirs. They have filed a suit for partition between themselves. Without making,
both are partition suits.
Yes, without making us parties.
That's right.
Yes,
That's right.
and
But
when I came to know of it, I have filed a petition in the final decree proceeding. After the preliminary decree, I have filed a petition before the.
Sorry, Reed Court cannot grant injunction when civil suits are pending.
My lord, no, I am only on the point.
You are asking for temporary protection.
Temporarily, that ROR may not be given effect.
No.
Otherwise,
I can only observe, since
yes,
there are rival suits, any outcome in the suit ultimately
because
abide.
in the meantime, they have already sold some of the property.
Go, fine, get an injunction.
Yes.
You are wasting time here.
My lord, that I have already given them.
So then let them fight out there.
Your lordship,
At the submission
my lord, your lordship, with that observation, your lordship may dispose
at the
it of.
submission of Mrs. Zena and Sri Das, as well as Sri Ponda, counsel for different parties. Read petition, even though involved, and a final outcome in mutation appeal 14/2021, pleading as well as submission of respective counsels brings there has been rival civil suits pending for consideration at some stage or the other. An attempt is made by the counsel for the petitioner to at least to get temporary protection, at least till injunction aspect is considered by the civil court. For there is concrete material, the parties are in the civil litigations. This court finds there is no question of entertaining such relief here. Read petition the stand disposed, simply observing. Okay, this read petition stand disposed while relegating the parties back to find out the remedy available through the pending civil suits. It is, however, observed the ultimate decree in the civil suit, judgment and decree in the civil suit shall bind the parties involving the outcome in the MA.
My lord, may I another? I don't think it will be prudent still. CS number 65 of 17 and CS number 2 of 16.
Dita ka mention kar de.
Dita ko mention kar dele ठीक होगा. Oblige my lord, your lordship. Urgent copy of your lordship, sorry. Urgent copy of your lordship.
Urgent. Yes. On proper application.
Item 13.
May I please your lordship? Well, arises out of a election dispute.
Arises out of a
election dispute under the GP Act, my lord.
In a miscellaneous application or final?
No, my lord, it is at the stage, security, I am the returned candidate. My election was challenged. Security deposit was not made. Election petition was filed on 8/3/22 and security deposit was made in 27/12/22. Almost.
What is the decision governing the field?
Well, I have got a Supreme Court decision or of course under the RP Act.
Our High Court is there.
RP Act, it says unless.
Our High Court, RP Act, our High Court decision is there. My decision has been reversed by a division bench of this court.
Because there, in that decision. Well, here what your lordship may kindly see that page, that order itself.
Yes, let us presume that there has been no deposit by the cut-off date.
Yes.
There is a decision announced kahinki.
Se decision tar kon heitala ki setere 2 din deri re heitala boli seta condone kar dedala. Apano reject kartele division bench कहले जे नाही 2 दिन जेहेतु चालान टा deposit heichi tenu it is in compliance.
That is no, division bench said it is no compliance.
I have got a division bench decision.
No. My decision, I say, जेहेतु चालान deposit heijaithala, tenu the party is not in fault because magistrate did not sign the चालान by the end of the day.
Yes.
Man was ready with money in the counter.
Honorable Justice.
So I took a lenient view. Jehetu magistrate is at fault, party should not suffer. Now the division bench said, no, provision one said the deposit must come by the cut-off time. Unless it is deposited, it suffers for the statutory.
Division bench confirm your lordship judgment.
No, these are the Padinati things. Day after tomorrow.
That is the decision of Amitabh Rai, Honorable Justice Amitabh Rai. And
that is SK Mishra.
Justice SK Mishra, sitting with Madam Ratha probably. Anand. More decision
here we have deposited, my lord. One mistake is only there.
Again, day after tomorrow.
Day after tomorrow. Say decision Anand.
Again,
Jadi Justice Amitabh Roy judgment thibo favoring my judgment.
Yes, madam.
How the other division bench jadi setaku ignore karithibe, then I may recommend for a larger bench decision.
Yes, I have brought that decision.
Vis-a-vis Sanatu Sanjay Mishra judgment.
Here we have deposited by mistake. It has been written as
lose
true. Again.
I am not close my mind.
Yes, madam. Day after tomorrow.
Day after tomorrow.
Item 14.
Did I get a judgment copy?
Yes, sir. Again.
No, I don't say. My judgment is reversed. Therefore, the division bench judgment is to prevail.
Yes.
But what you say, Justice Amitabh Rai has passed.
Your lordship judgment has been confirmed.
Therefore, dekhiwa jodi dita ka judgment contradict korthibo, then matter has to go to a higher bench.
Yes. Now here only that, my lord, in place of election dispute 3, it has been deposited in the election number 2 of 2021.
So that has
by mistake, but we have deposited that.
That has to be again seen.
Examined.
Party na uda ko thik achi ki nahi.
Party na thik achi, advocate name thik achi, sabu thik achi.
May I please, your lordship? My lord, here the petitioner challenges the inaction on the part of revenue authority, my lord.
Pardon?
Here the petitioner challenges the inaction on the part of revenue authority, my lord, Tahsildar, in not taking proper action on the acceptance of declaration and distribution list by the Bhudana Samiti, my lord. Earlier, the petitioner has filed.
Inaction or illegal action?
Rejection. It is against rejection.
Against a rejection.
Yes.
Annexure?
Inaction, that is rejection by settlement authority, my lord. Settlement authority on the ground that Tahsildar has. Annexure 7, my lord, at page 70. 70.
But your
Cemetery settlement authority reject kale on the ground that there is
So,
no jamabandi from Tahsil.
Where have you challenged Annexure 7?
I have not challenged Annexure 7, my lord.
How- What is your read there?
My prayer is due to inaction on the part of revenue authority Tahsildar,
In not working out Annexure 3,
my lord, Annexure 2, 1 and 2, my lord.
not working out Annexure 1 and 2.
My lord, that they have to
ଟିକେ
confirm
ଆଜ୍ଞା,
the declaration, my lord.
ଟିକେ ମୁଁ clarify କରିଦଉଛି ଆପଣ ଟିକେ page 69 କୁ ଆସନ୍ତୁ that SO's order. ଆପଣ ମଝିକୁ ଏଟା ହଉଛି last but one paragraph ଟା page 69 SO's order.
This is what proceeding?
This is a objection before the ASO.
Objection.
Objection, yes.
Okay.
Page 57 ରେ ସେଟା indicate କରୁଛି order sheet ଟା objection before the ASO. So certainly it is relating to publication of ROR, final publication. Lordship sees this sabik मुझे page 69 ରେ place କରୁଛି.
Page 67.
69
69.
again. Say continue କରୁଛି ସେ order.
Sabik ROR.
The Sabik ROR of Moja Sampur was finally published on 12/3/1962. The petitioners or their predecessor could not get their names recorded in RORs 1962 and could not agitate their claim in different stages of settlement operation like Kistwar, Khanapuri, Gujarat, attestation, draft.
None of this stage he objected.
It is not understood why claimants were silent for such a long period. It is also revealed that the land allotted in their favor has been recorded in government holding. Besides, it is amply clear that the RORs have presumptive value of evidence under section 13(3) of the OSS Act. Since in the ROR, the land are recorded under the government khata, the Tahsildar is bound by law to presume that the land belongs to government without iota of doubt. The revenue Moja Sampur has already been declared as urban area and the recorded government lands are presently under the control of management of jurisdiction of GA department. Besides, peruse the field inquiry report.
Civil suit re jaunandi.
My lord,
Declaration.
Tahsildar has to confirm under the Bhudan and Gramadan Act, my lord. Because the donation.
But you don't challenge this order.
No, my lord, I am not challenging Annexure 7, my lord. Because
if you don't challenge that, that's an order negating your claim.
My lord, may kindly peruse page 70, my lord. At the bottom paragraph, my lord.
Yes.
That has been negative because in view of the above fact and circumstances, as well as after careful consideration of the status report supplied by the Tahsildar Bhubaneswar and field possession report submitted by the court inspector, clarification of government in R&DM department issued by.
So this court is declined to record the suit land in favor of the petitioner. Are you not the petitioner?
My lord,
You are the
due to,
petitioner.
my lord, due to want of a Jamabandi by the Tahsildar, my lord. Jamabandi is to be granted by the Tahsildar under the Bhudan and Gramadan Act, my lord.
That where from you are finding?
My lord.
Where from you are finding that due to want of Jamabandi only it has been
My lord,
rejected?
in that paragraph, my lord. Last line. The prayer for the petitioner is rejected and a claim is also disallowed due to want of Jamabandi in respect of the claimed land, my lord.
Now that the
Therefore,
land
I have
stands
approached
recorded.
this honorable court, my lord.
Then Jamabandi is whose responsibility?
My lord, Tahsildar, my lord. He has to confirm, my lord. The donation and declaration is to be confirmed by the Tahsildar.
No, the land which is supposed to have been donated in favor of the petitioner, my lord, that land stood recorded in this during settlement operation in the name of.
You bring your counter. You bring your counter. Take notice. This is a notice on the question of admission.
My lord, I have filed a IA seeking protection of my possession.
You are in possession?
My lord.
Okay, provided the petitioner in possession of the disputed land. His possession
GA
may not be disturbed till disposal of the writ application. IA disposed of.
15, 16 and 17 same, my lord. 15, 16 and 17 same.
How
my
would I
lord.
say?
My lord.
All right, 15, 16, 17, all three. Requisites as undertaken by day after tomorrow by way of service of copy on the state council.
My lord, there are other opposite parties. Other opposite parties.
Private opposite party.
Arrested.
Notice to private opposite party by big post AD.
Oblige, my lord.
Item 18.
18, my lord. In this case, I am challenging the inaction by the opposite party number 2 regarding mutation of the land against plot number 91C of under drawing D by 360.
You have a mutation proceeding pending.
My lord.
Where
But the
is that
statute
mutation?
says, statute no provision is said within 60 days of Kariya Katha. That is annexure 4.
Annexure
4. At page 25, the provision. Conversion, mutation and mortgage permission NOC. Issue of a mutation order of the leasehold land within 60 days by
right.
the,
Have you brought a mutation petition?
yes, madam.
Where is that?
Serious. By virtue of order, se nije kariya katha. Se nije kariye.
High Court order?
High Court order.
High Court order कौन कहला देखिले?
High Court order टा फाइल करनी से मागी थिले ओटे रिपोर्ट मते जे High Court order कोन हला against the suit सेटा मते मागी थिले सेटा हम फर्निश करला पर से कर दवा कथा. That has been furnished on
No, normally mutation proceedings are initiated based on a either 15B order or 37(1) order that says so moto mutation.
So,
right to initiate a mutation.
99 ru pending अछि. Then right
pending अछि.
Mutation say against the plot number.
You are unable to demonstrate where is the mutation case pending. You are simply bringing a notification of the government, annexure 4. That cannot satisfy that you have a mutation proceeding pending. That's simply a guideline.
Letter कोठी जगह लेखुना दी mutation case number such and such किछ लेखुना.
आपण at least देखुना दी कोन application आपण फाइल करछंदी.
आमे फाइल करछु under annexure 3 series matter. That is a
series.
Page 19. That as per your office letter number,
No,
such
this
and
is
such.
a representation.
No, representation. As per office letter number such and such, I submit the certified copy of the order dated 11/3/2004.
You take instruction as to whether any mutation case is pending. Because this is a letter appears to be. They are bringing to the notice of the mutation authority regarding some development in High Court.
No, High Court, but that is concerning a suit. The suit amendment petition allow since it was not changing character and nature.
He is unable to say whether if many mutation.
That is not relating to any deciding any title or anything.
You bring material that your mutation petition is pending.
And what happened to that suit also, that is also not
Withdraw karikiri proper application file karan.
Oh, right.
There is no appearance of filing of or pendency of any mutation proceeding. Counsel for petitioner wants to withdraw the writ application in order to bring the appropriate application. He is permitted to withdraw, however, with liberty.
Okay.
Item 19.
Future Lordship. My lord, this is a mistake. Annexure 6, original order has not been annexed, another one is annexed. Annexure 6, my lord. 1 page 76.
Annexure 6.
My lord.
Annexure 6 here is a letter only.
No, my lord, that is averment taken by me. That is the letter issued by OP number 4 to appear before him.
Then how can that be replaced now on your extending a paper here? You bring amendment.
My lord.
There is some wrong descriptions in the pleading. Petitioner wants to bring amendment. Place this matter place this matter on Thursday along with amendment application, if any.
My lord, only that page will change. That is the amendment.
prayer
Prayer ago anantu, tapare se page ta ko page.
My lord, prayer is not necessary because I have already averred that averment has been taken.
Only mu ଆଉ ଏତେ ବୁଝେଇବିନି ଆଜ୍ଞା ମୋ ଲାଇଫ ଷ୍ଟେପିଂ ହଉଛି ଲୋକ ଆପଣଙ୍କୁ ଖରାପ ଭାବିବେ ମୁଁ ଡିସ୍କସ କଲା ମାନେ ଲୋକ ଆପଣଙ୍କୁ ଖରାପ ଭାବିବେ ଓ ମୁଁ କି ଓକିଲ ହାତରେ ପଡିଲି ବୋଲି କହିବେ
Item 20.
May I please your lordship? I am challenging the
your demarcation case is still pending.
Yes, my lord.
Okay, all right. Through annexure 3, it is established.
My lord,
pendency of a
present petitioner is a widow lady, widow woman. He has she has no house. Present petitioner घर नहीं गोटे पॉलिथिन पकई रहउचंती आउ जेहेतु एटा प्रॉपर मार्केट एरिया रे लैंड ता रही adjacent plot जो माने अछंती से माने डिस्टर्बेंस करउचंती
ହେଲା ପିଟିସନ ଦରଖାସ୍ତ ଅଛି ସେଟା କରାଯିବ ତାଙ୍କୁ ପକ୍ଷ କରାହେଇକିରି ଆଉ କଣ କରାଯିବ ଆଉ କଣ ଚାହୁଁଛନ୍ତି ଆପଣ
demarcation with stipulated
ହବ ଦଉଛି ଅର୍ଡର yes through annexure 3 it has been established that petitioners have a pending demarcation case registered as 164 of 2022 on the file of Tahsildar Khoida involving Mauja, Khata, Kasada, Kisam, so page 13 re achi hela. Okay, considering pendency of a demarcation proceeding while expressing its anxiety for long pendency of such proceeding, this court direct the Tahsildar Khoira OP number so and so to conclude such proceeding in the involvement of the boundary tenants at least within a period of 10 weeks from the date of communication of order.
Obligement.
Item 21.
May I please,
yes.
If the opposite party without any prior notice or without any announcement, now the construction work over the short land property, Lordship, under annexure 1 series, running page 8, Your Lordship. That is Amruta Sarovar Yojana project, Your Lordship.
Your grievance is the construction is disturbing a playground.
Yes, Your Lordship. That is a playground and khola bhi hochi sethire and both the
who are you?
The petitioners are villager of the
villagers.
Yes, Your Lordship.
Apan kon khelanti?
The playgrounds for the children,
for the children.
Yes.
Apan manko pilanga pai.
Yes. Our pokhori ta the adjacent plot is also.
Pilanga pai with the pool lection your children are obstructed from playing.
That is a playground. Your Lordship, for a moment, kindly see the running page.
All right. At the same time, you have also a pending request.
Annexure 4.
What is the stage of construction?
Now still going on, Your Lordship. I have annexed the photographs, Your Lordship.
It's already constructed, commenced. They already had the submission of Planet Council for the petitioner. Considering the grounds stated herein, this court here find there is no dispute that there has been already commencement of the construction of a pond. At the same time, this court again find the petitioners have a grievance in the illegal utilization of the vacant land, thereby preventing the villagers from their several use of the said land. Considering request of the petitioners pending with the collector Jaspur, this court direct the collector Jaspur to convene immediate, involve an urgent inquiry to find if the interest of the villagers at all disturbed by undertaking such exercise in the involvement of the villagers, at least within a period of 15 days of the receipt of copy of order. Free copy of order be handed over to State Council.
May I play within a period of Your Lordship?
ये तो पोखरी देखेलानी पाँच ही गलानी सब.
नहीं ता साइट टा भी गोटे पोखरी already अच्छी सेटा को develop करू ना हंदी but they are doing adjacent the plot, Your Lordship.
Okay, provided there is no construction commenced, the construction of the construction of the development, if any, be not undertaken for at least 15 days.
Develop.
Yes.
Item 22.
My lord, pendency of requesting application followed by statutory K form quota annexed on page 21. There is a covered order.
Any order supporting you? Okay, form.
K form. K.
Beyond. ये के रो कोन आपण ओडिशा जाकर पट्टा नहीं जाइछन्ती कि every alternate day I find some K cases coming. आउ लंबोदर प्रधान सबुतरे उकिल
इंग्लिश अल्फाबेट सब केटा को बाहर कर दे जति हो.
Yes, next.
Item 23.
Well, here is the case, actually journey started.
माइक आपण को ऊपर को पळेला.
Oh, sorry. I'm sorry. Well, the journey started in 1975. Actually, this land, some one deity claiming to the property, ultimately the property belonged to Orient Paper Mill. But anyhow, there was a compromise. The Lordship kindly see page 7. Page 7. There was a compromise in this Hon'Ble Court, OCC, Pilot Justice, led J.K. Mr. CJ was the Malad. In that case, the compromise petition was filed. Lordship got it, Malad. Page 7. I have quoted that order.
Yes, yes.
Last 4 line in this context.
Yes.
In this context, parties entered into compromise, offered their terms voluntarily, and we are satisfied that the compromise is beneficial in the interest of the deity. By the compromise, the title of the petitioner to the suit property has been declared, and petitioner takes up upon itself obligation to making certain payment annually, which have been fully embodied in the compromise petition itself. So title was declared by this Hon'Ble. It was disposed of in terms of the compromise. Then, my lord, what happened? The
title of whom?
Title of Orient Paper Mill. Orient Paper Mill.
Managing trustee of Ramji Temple.
Ramji Temple. Title of Orient Paper Mill was declared. My lord, when Orient Paper Mill wanted to dispose of this,
sorry, Mr. Mishra.
My lord.
Title of.
Yes, my lord.
Petitioner is Orient Paper.
Petitioner is Orient Paper Mill.
Yes.
So what has happened, my lord? Thereafter, when the matter, when Orient Paper Mill wanted to transfer the land to me, to the present petitioner, but there is a problem. The opinion was sought from the endowment commissioner. My lord, the Lordship kindly see page 11. Page 11.
Yes.
Endowment commissioner, what endowment commissioner says. When the Hon'Ble courts in his order have been pleased to accept the title in respect of the disputed property mentioned in that writ application in favor of Mrs. Orient Paper Mill, and when the terms and conditions of the said compromise petition are also accepted by the Hon'Ble court, at the time there is no impediment of the title holder to deal with that property at his choice. Accordingly, order dated to pass by this.
Commissioner passed.
No objection. There are pilot the registration was placed, but registration author did not agree to register the property. The registered appeal, the appeal was filed before the registered ballot. Page 1616. Page 16, ballot, last part 1 para. In view of the above, appeal is allowed and district sub-registrar Hon'Ble is directed to accept the deed of registration.
Yes.
Despite that, my lord, it was not done. Then, my lord, your lordship matter came before this Hon'Ble court, and in your lordship's order, your lordship kindly see page 18, 18.
Yes, I have directed.
Your lordship, after that only it was registered, my lord. My lord, after the register, I filed application for mutation.
Now,
mutation, my lord, was rejected, and what then preferred appeal. What appellate authority, my lord, has become a much higher than Supreme Court, but says that now he said that Orient Paper is only a Sebayat. Lordship kindly says rejected page 37, my lord.
Yes, Mr. Ghosh. He is sitting over the division bench even. Order passed in 75 declaring right title interest of favor of the party. So कौन करिया आपण सुनतु माको objection file करिवे की
instruction टा निये काहे
instruction टा नियंतु
instruction टा गोटे instruction नियंतु सेतिरे
instruction नियंतु I will be taking up this on next Monday.
Ballot. So that it can
be. Okay, read petition involve challenge of an order of the mutation authority in mutation appeal 38 of 22, prima facie appearing to be sitting over the High Court judgment, a division bench judgment of this court passed in OGC 43 of 74, order date taker 29/4/75, and there has been further development by way of a single bench judgment again by this court in the disposal of WPC. Kete page re thila mo?
Page 18. 18.
Yes, disposal
Now case number was page 179.
18439 of 2019 on 30th/9/19. There is clear disclosure after the single bench judgment oblique order. There has been registration already by the competent authority. Mutation being applied, the mutation has been rejected. Mutation ta reject kar dala.
Mutation reject kar dala.
And an appeal being preferred. Appeal has also come to be dismissed. There is prima facie satisfaction. This court prima facie is satisfied that attempt of the mutation authority appears to be overreaching the judgment of this court since 1975. State Council at this stage seeks time to take instruction. Instruction should be confined to lawful on the legal aspect of the matter. This court, even though find there is no question of instruction from the parties involved, however, provide opportunity to the State Council to find the position of law on this aspect. Place this matter on Monday. Khali position of law, nothing else. Chapter is totally closed.
15th panel.
Yes, 15th. Monday, 15th.
Deeply.
The free copy of the order. No free copy.
Free copy of order.
Item 24.
May I please, your lordship.
Yes.
Joan lease was granted in the year 1989. And thereafter, the lease pata was granted and also sale deed was executed. But in the meantime, Tahsildar tried to resume the land under section 3B of the OJLS Act and finally dropped that OJLS proceeding. Subsequently transferred to different person and finally come to Mr. Mahanti, the petitioner. And while the situation to the settlement operation came, and in the settlement operation, the land of the petitioner kept in the government khata abada jogya anabadi.
I'll let you take notice.
And your lordship, in similar matters, relying of the decision of this honorable court, past order, the same order may be carried here.
No, division bench judgment apna e case re kemti anuchanti.
Hajur भी pass कर
division bench judge mo judgment ठीक अछि mo judgment apna देखि पारंती mo करिछि just ये मिस्टर मनोज मिश्रंकर केस रे भी mo करिछि अल्प दिन तळे जवान लीज केस हला किंतु डिविजन बेंच रे कोन सेम इश्यू थिला डिविजन बेंच तो जवान लीज इश्यू नथिला आपण जो डिविजन बेंच रो जजमेंट देखौचंती एठी
मेल
सेथिरे जवान लीज इश्यू थिला वाज इट इज इश्यू काई एडा देखौचंती एसोर जुरिस्डिक्शन डिसाइड इज सिटी
your lordship call this matter tomorrow my lord
एग्जामिन करिवे ना खाली इठी आसीची इट्स नॉट ए जवान लीज इश्यू एट ऑल my order you may be showing more ଦି ତିନିଟା case जवान लीज ऊपर कलनी तनु सेटा ही पारे so both the no this order is also not जवान लीज case
सेटा वेस्टलैंड लीज केस गुडा जो ये हेतले से नरोत्तम केस जो रेफर करछन दैट इज डिफरेंट थिंग दे सेड दैट सेटलमेंट अथॉरिटी कोन जो देगा नहीं वांस इट लीज डाउन
देखो फाइंड आउट जवान लीज केस रे मोर दीदीटा जजमेंट हलानी ए डबल एल केस ऊपर हलानी तनु आणतु सेही जिंस आणतु सेठी म्यूटेशंस दे कैन डिक्लाइन and as appears in this case there is previous round of litigation event
My lord.
से जजमेंट काई
सब अच्छी
3-6
अच्छी
अच्छी आदर देइछंदी
आगे आगे
अनेश्वर केते हाँ यस अनेश्वर 11 probably ये कौन है लोक प्रसन्न कुमार महाती
आगे
सो अनेश्वर 11 रे कौन है अल्टीमेटली हाँ ये सब तो सही ऑर्डर से सब होल्ड करथिबे किंतु पुणी रिमाइंड कर देथिबे और सेठी से कहले अपील अछि पळा अपील को आपण अपीलेट कोर्ट जाय के आसिलेनी
आगे
day after tomorrow on the request of the learned counsel for the petitioner पूरा डेट चार्ट करके आनिबे हला
आगे सिमिलरली मैडम 25 27 28 29
25
27
27
28
28
29
29
आगे
नॉले yes
Item 26.
आपण टिके भी भितर एग्जामिन करंतु
आगे
हला जबान लीज केस रे मु जजमेंट देइछि मिस्टर मनोज मिश्र कर केस रे एफआर हेछि किंतु रिपोर्ट हेइनी थारे जबान लीज हेइ गला परे ताकू आपण गवर्नमेंट को अब नहीं परिबेनी से केस ता आपण मन थिवो जस्टिस महापात्रकर ऑर्डर रु कंफ्यूजन हेतला
आगे
पांचटा पार्सल बिक सारला परे 6 पार्सल टा गवर्नमेंट को नहीं जाइछन yes
Item 26.
Please, my lord.
yes Mr. Das
This is under the ombudsman decided a case directing that payment
ombudsman order you are challenging
here.
LIC insurance ombudsman
Insurance. No,
you are the claimant
my lord, company.
company
What has happened, my lord, here,
so
it's
claim is
totally
allowed.
fraud, my lord. Somebody went to the hospital, got the ID number, and then when operation was advised by suppressing that, my lord,
kahi certificate copy kahi answer 7 ro
that is the copy which was
no it can't be
authenticated copy, my lord.
it can't be it's a xerox copy xerox करकरी signature original रहइबो
Signature original हमको तो ombudsman देना दे copy
आपण
forward.
फाइल रे थिबो देखंतु
No, my lord.
ये एस्पेक्ट टिके देखियो दिया ये एस्पेक्ट जान
एटा आपण पाखु जो ट्रू कॉपी आसीची तार जेरोक्स आपण फाइल करछन this is the order impugned here
No, original I have filed. Whatever we have received, that is
original kind आपण फाइल रे बंधा हितबो
no,
नले आपण फाइल भीतर थिबो
no. I checked it, my lord, at page 38, your lordship sees.
38 I am holding here it's a xerox copy you have attested only as true copy
That we have attested.
ताको सिग्नेचर थाई कॉपी काई these are non-judicial orders therefore copy is communicated only therefore the original must be filed it may not be in certified copy format
That's right. For the
Yes,
time being, your lordship.
notice subject to filing of certified copy of the original copy of the Annexure 7 within at least 15 days. Requisites for issuing notice to the এটা করিব পার্টি অ্যাকর্ডিংলি করব না Yes, in the meantime, there shall be stay of the impugned order and issue 7. ସେ କଣ ହସ୍ପିଟାଲରେ ପଇସା ଦେଇ ଦେଇକି ଯାଇଛି ଆପଣଙ୍କୁ ପଇସା ମାଗୁଛି ଆପଣ ଦଉନାହାନ୍ତି।
ନା 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 ଆଉ ଗୋଟେ ପରେ ଗୋଟେ ଆଉ ଗୋଟେ ଆଇଡି କରିଦେଇକିରି କ୍ଲେମ କଲା ମାନେ ଏକ୍ଜିଷ୍ଟିଂ ଡିଜିଜ ଟାକୁ ସପ୍ରେସ କରିଦେଲା।
That may be merit in the case. But ସେ ପଇସା ଦେଇ ଯାଇଥିବ ନା ବର୍ତ୍ତମାନ ଅପରେସନ କରି ତା ପଇସା ଦେଇ ଦେଇକି ହାତରୁ ଯାଇଛି ଆଉ। You dispute that this is a fake ID.
Yes, that
Therefore-
also now stands admitted by the hospital people.
Hospital is also a party.
Yes, Amri Hospital.
Amri.
Did ID create କରିକିରି
ହଉଛି ଆଜିକାଲି ଆଉ କଣ କରାଯିବ ତ ଟେକ୍ନୋଲୋଜି has its vices. ଏପରା ଏବେ ଆସିଲାଣି ୱାର୍ନିଂ ଆସିଲାଣି ଆପଣ ଅନନୋନ୍ ଟେଲିଫୋନ ହେଲେ ଧରନ୍ତୁନି। ସେ ଆପଣ ଧରିଦେବେ
ଆପଣଙ୍କ ବିଲରୁ କଟିକିରି ଚାଲିଲା।
ସିଏ କିଛି କହିବନି ସିଆଡୁ ଖାଲି ସେ ତାର ସାଇଲେଣ୍ଟ ରହିବ କିନ୍ତୁ ଆପଣଙ୍କ ବ୍ୟାଙ୍କ ଆକାଉଣ୍ଟରୁ ସେଟା ସବୁ ଲଣ୍ଡା ହେଇଯିବ। ବର୍ତ୍ତମାନ ଏ ଲେବୁଲକୁ ଗଲାଣି ସେ।
ନାଇଁ ଭାଇ ହୋଲ୍ଡିଂ ଫର ଫ୍ୟୁ ସେକେଣ୍ଡସ ଆପଣଙ୍କୁ ସବୁ ଡାଟା ପଳେଇବ।
ସବୁ ପଳେଇବ
ତା ପାଖରେ ସବୁ ଡାଟା।
Yes, next.
Item 30.
Are permitted to withdraw. Last time your lordship directed me to examine the matter. I have examined and nothing to be argued. Therefore, I want to withdraw this case.
Okay. Counsel for this 6 withdrawal of the writ application.
I have filed the memo before the court master.
Memo be kept on record. Permitted to withdraw.
Item 31.
I have challenged the order in annexure 2, page 17 and 8.
माइक क्या करेगा?
Sorry, madam. Your lordship, see paragraph 17 and 18. 17.
15B order I am not entertaining. What is that legal flaw here? 15B I am not entertaining with a view. You can go for civil suit. So what is that patent error?
My lord, that
requiring to interfere?
Yes, ma'am. That I have shown. My lord, your lordship, see, he has purchased a land that is in Khata number 20, Sabi Khata number 20, plot number 60 by 121, plot number 60 by 122. So 60 by 122, 4 decimal, 60 by 122, 4 decimal. My lord, thereafter, my lord, he
where
has
you given opportunity of hearing.
No, my lord, he has not given me opportunity.
Where have you pleaded that?
Yes, my lord, your lordship, see the order itself.
No, order says
the legal
advocate for petitioner has prayed for condonation of delay. Delay is hereby condoned and revision is admitted. Petitioner is present today. Notices duly served on OP 1, 3 and 8.
Though
notices sent to rest office back answered by registered post and noted absent on the envelope. Anyway, they are partly served. So therefore, who are you here? You are one of the opposite party there.
Yes, ma'am.
So where is the cause title in that RP?
Well, this is annexure 1.
Yes, annexure 1, page 13.
Yes, madam.
So this order shows
I am
notice duly served on 1, 3 and 8.
I am 9.
1, 3,
8.
8. Apana hele
9.
Apana 9.
Yes, madam.
What is the relationship between you people?
9 is my father is the son of Hadibaru.
So therefore there is substantial representation, Mr. Patnaik.
No, man, that how it is substantially printed. My lord, we are all different. Now all are
one issue remains. On the date of
my lord,
delay, how can he dispose of the matter?
My lord, that there you lord.
So let us issue notice.
Lordship.
It is surprised to find from the impugned order that on the date of condonation of delay itself, the 15B proceeding has come to be disposed finally. It is only on this ground this court is inclined to issue notice. Status quo, miscase status quo in respect of the disputed property. आपण से ground argue करना है दी. जो ground रे admit है ला से ground आपण argue करना है दी.
Admit.
बुझी पार लें.
Stay.
Notice कॉलोनी. बाकी से बाहर बुझे ही दे. बाकी से बाहर बुझे ही दे.
Stay impugned order.
परसल लें.
Item 32.
May please your lordship.
Yes.
Your lordship may peruse annexure 5 at page 35, your lordship. Page 35.
Yes.
The opposite party number 3 has issued a letter for correction of voter list. Your lordship, this letter was challenged before this honorable court in WPC number 2722 of 2023, and your lordship granted the issue while directing for take instruction. Your lordship may peruse page 18 of my brief. I have quoted that order.
Yes.
On 7 of February 2023.
Para 2 padhandu.
Para 2, the sole question involved herein, when subsection 2 of section 4 of Pani Panchayat has prescribed that the superintending engineer is the authority in charge in the matter of election of Pani Panchayat, if there is any possibility of indulgence of additional chief engineer is undertaking, the correction is of the beneficiary list.
That execution is still pending.
Yes, your lordship. Your lordship may peruse para 5
yes,
at page 19. Place this matter on 21st February 2023. Progress, if any, taking place by virtue of annexure 5 shall remain
subject to.
Then what happened, my lord? Annexure 6. A similar order to bypass to order of this honorable court, a similar order was passed by same opposite party on 19/4/2023, inviting objection regarding beneficiary list.
On the same issue?
Yes, your lordship, on the same issue.
ताले आरो रिपिटिशन टा इनफ्रुक्चुअस हे गला ना नहीं
हाँ absolutely
ताले आ संगे सेटा आसु से को विथड्रॉ करिवे एटा सिमिलर ऑर्डर टे पास कर दवा
आगे
tomorrow
मु सेही थरे फाइल भी करथिली
आगे आपन ता संगे रा को आनथांद ना
आगे
along with WPC 2722/2023
आगे
2722 of 23 tomorrow
obliged
काली हबो कोर्ट मास्टर काली आसपरियो सेटरे मेमोटे दे देबे विथड्रॉ करिया पे फॉर फर्दर कॉज ऑफ एक्शन
आगे
Item 33.
They mistake he has committed. Because assistant engineer look.
Lordship, I perused that.
Assistant engineer.
My lordship.
Again, that chief engineer or somebody.
Lordship, that should not have been done. Lordship, I perused that.
Item 33.
33 may permit to conduct the case through VC.
Yes, yes. VC पूरा chief justice India कहले VC permit करा जाओ बोले आओ permission मांगिया दरकार नहीं when CJI says.
Lord, what happening is I am the purchaser of one portion of the land. And during settlement, my lord, in the meantime, my lord, not final ROR has been issued. But that was not recorded in my name. Subsequently, I got the information that
what happened? Proceeding under annexure 3 is entertained or not?
No, that was not accepted, my lord.
Accepted?
Yes,
not accepted.
Not accepted.
Oh, you accept it and pass lawful order.
If settlement operation is still open, then it has to be accepted.
Yes, yes, it is still going on.
Suppose, Mr. Mishra, suppose settlement operation is not there.
My lordship.
You may say it is not maintainable.
Lordship.
But you can't return the applications.
Lordship.
He has had the submission of respective councils. One side, when claimed settlement of operation is in the area involved wherein is still going on, State Council submit it has no instruction as to whether The area is still under settlement operation, providing adjudicatory power with the assistant settlement officer herein. Okay, without entering into such controversy, considering the application of the petition annexure 3 is not entertained even in the disposal of writ application, this court observed, in the event petitioner retenders the application by annexure 3, then shall be accepted, registered, and a lawful order shall be passed involving such application in the involvement of the petitioner and contesting opposite parties. Yeah.
Item 34.
The rest 35 and 34 and 35 are similar matters.
Similar.
Up to 35?
Lordship.
Yes, my lord.
All right.
33, 34 and 35.
Item 36.
36, your lordship, is first contempt. Lordship.
Huh?
It's a first contempt matter. Lordship.
First contempt.
Lordship.
All right. First contempt disposed. 36.
For orders, item 37.
37.
File.
Your
Just
lordship,
1
may
minute.
kind
Fix
ଆପଣ client କଣ instruction ଦେଲା କଣ ଲେଖାରେ ଯାଆନ୍ତୁନି
notice
ଆଚ୍ଛା expiry order ହେଇଛି କି
expiry order there is no reflect in judgment
improved order ଟା ଦେଖେ
Yes, your lordship may see page 8. Notice was directed to be issued in 2015. Issue notice to OP.
Yes.
The case is taken up, petitioner is next date, submit law point regarding such and such. Then dates rolled on. Your lordship will see 1610, the next page, page 9. Case taken up, petitioner is absent, OP is dead. Substitution is filed, issue notice to the legal heirs of the deceased OP. Then next page, advocate of the petitioner present, issue fresh notice to OP. Advocate of petitioner present, heard.
Who legal heir ଆପଣ ପାଇଲେ?
नहीं से मरीगला जो
नहीं आपण पेज 10 रे जो कहले इश्यू नोटिस टू ओपी लिखाई जे आपण कहले लीगल एयर कोड लिखाई
नहीं तार ऑर्डर एटी अछि
ता पूर्व ऑर्डर रे थिला ओपी
16/10 रे 16/10 रे ऑर्डर लिखाई छी एडवोकेट
सेटा के मना करूची की
आज्ञा
वर्तमान से पढुचंदी 18/12/15 ऑर्डर टा
आज्ञा
सेठी लेखा हला नोटिस टू ओपी ओपी लेखाबा कथा नो एलआर सब ओपी लेखाबा कथा
एलआर सब परे आसी
परे तापरे कोन हला
Manner advocate petitioner present, heard, order is not ready, put up for orders. Manner your lordship may kindly see.
So therefore order sheet express clears heard submission of the respective councils. Impugned order annexure 1 is challenged only on the premises of no notice to the LRs of the opposite party in consolidation case number 1547 of 15. This court considers the submission of respective counsels. One party when claims there is no notice to the LRs, the present petitioner here. Other side taking to the observation in the impugned order submits there has been notice. This court reading the order sheet filed herein, commencing from page 8, page 7, finds order dated 25/6/15, 20th/7/15, 21/8/15, 16/10,
1610 15.
15, 18/12/15, 22/1/16, and 15/2/16, which reads as follows. Judgment, impugned judgment appears to have been passed following the observation in 15/2/16. In entire reading of the aforesaid order sheet, this court nowhere find there is any observation on service of notice on the legalness of the OP at all. Deceased OP at all. In the circumstance, this court satisfied that the impugned order is passed behind the petitioner's hearing. As a consequence, this court is constrained to interfere in the order dated 4/3/16 in consultation revision 1547 of 15. Accordingly, set aside the same. However, for there is fresh requirement of adjudication of the 37(1) proceeding, 37(1) of OCH and PFL proceeding. This court direct both parties to appear before the Additional Commissioner Consultation and Settlement Sambalpur and or the competent authority presently on 15th May and take date of hearing. Based on proper adjudication, the petitioners herein may also bring their objection on the date of appearance. Objection on the date of appearance. कौन कौन
19 both party
19 all right 19
obliged.
Item 38.
My lord, 30, your lordship was pleased to direct me to deposit the cost of 1,000 rupees within the week. It was deposited but late. Kindly accept it.
Okay.
And-
Cost deposited late be accepted.
And another factor I may mention before your lordship, this matter relates to regularization. So may I
We'll go to
before the
appropriate bench.
appropriate bench.
Okay. Filed late is accepted. Looking to the nature of dispute, this court find this court has no assignment of this matter. Rest it to find out assignment and place it accordingly.
Obliged.
Item 39.
Mercy. This is the relating to the refund of the money, Lordship.
Oh, who was the petitioner?
Lordship, Ma Mangala WSHG,
Nata kono?
Kapita Mahanti, President namely Kapita Mahanti,
Kapita Mahanti had filed the petition.
Lordship.
Now the money will be refunded in favor of the institution.
Lordship.
So there will be no confusion.
My lords.
Okay, peruse the order dated 19/1/23 and the observation of the registered judicial. This court gathers based on the direction for refund. Kapita Mahanti, the president of Ma Manaso WSHG,
Olal Binda,
has filed the refund application.
WSHG Olal
Subuni,
WSHG Olal Binda লেখা হয়েছে
WSHG
Olal Binda
Allal Bindha, Allala Bindha, Allala Bindha. देखी तो cost title আছে না? In the interest of justice, for there is confusion raised by the registered judicial apprehending mishandling of the fund. This court direct the amount accrued with the deposited amount along with accrued interest be released in favor of Ma Manaso WSHG Olala Bindha Hela. Yes. These are direction, fiction flows. The matter flows with this direction. Hela. Fiction. Yes, 40.
Item 40.
Item 39, extension of time. Item 39, extension of time.
39.
Extension of time, Lordship. Your Lordship has disposed this matter, but I have.
Our extension of time kon? O setire time kichi thila, stipulation thila?
No, item 30.
Oh, he's mentioned, my learned friend is
no,
mentioning item
sorry,
41
sorry.
for us.
41. Sorry, man.
Item
Your
40.
Lordship.
40 who is there?
My lord, item 40, your Lordship has passed order to deposit 30,000 rupees within 7 days. He is a very poor man and a handicapped poor man. So I prayed for a two weeks extension to deposit the amount.
Okay, considering the difficulty faced by the petitioner in making the deposit as per order dated 11/4/23, this court extend the time for deposit by another 2 weeks.
My lord.
All right.
All
This observation, the miscase stand disposed.
Item 41.
Item 41, Lordship.
Extension of time.
Extension of time, Lordship.
Kon matter kon?
Lordship, this is a disposed matter.
The order already heichi.
Lordship, I have made a representation to the council.
Okay, ame to eta dispose petition da.
Lordship,
3 weeks time bhitere kariya pai kuha haitala.
କୁହା ହେଇଥିଲା 4 ଦିନ ଭିତରେ ଅର୍ଡର ଟା ଦବା ପାଇଁ କୁହା ହେଇଥିଲା କିନ୍ତୁ ଲର୍ଡସିପ ମୁଁ ଦେଇ ପାରି ନଥିଲି
But
ସେଥିପାଇଁ
why petitioner is asking for extension?
lordship
All
kindly-
considering the request involved within
kindly
the
come to
time
the order, lords.
target fixed by this court in the order dated 29/3/23 is extended by another 2 weeks. Hmm.
For
42,
addition,
man,
item 42.
42 petition is died.
Okay, it has been reported the pendency writ application, the petitioner has died. So writ petition doesn't survive. Dismiss accordingly. Say, partner matter ta di.
Again. Item 48.
Item 48, Mr. Kali Misra.
I may plead your lordship, my lord.
Picket, double profile.
I'm there, my lord.
Yes, yes.
On the last occasion, lordship directed the state to produce the entire file regarding the cancellation of license of notary license of the petition, my lord.
Lordship, I have the file. My lord.
Chichi.
My lord.
Then why High Court said the production of the
But the entire contention is there is no inquiry in terms of the rule 13 of the notary's rule, my lord.
okay.
I was never afforded any opportunity to cross-examine,
Okay, so I must have observed there.
Look at your lordship's last order, my lord.
You are placing the rule of the tray.
Yes, my lord. I placed the rule accordingly, lordship directed to examine that whether there was an inquiry or not in terms of the rule.
Okay, there is a second inquiry suggested.
Yes, my lord.
Second inquiry suggested. So what is your
Lordship-
observation?
Lordship, may I submit the rules, your Lordship?
Yes,
Lordship,
rules.
kindly have a glance at the rules.
Notary rule. Yes, 13.
Rule 13, your Lordship. My lords.
Yes.
Inquiry into the allegations of professional or other misconduct.
Okay, just 1 minute.
Lordship.
Let me get the rule, I mean act. Yes.
Lordship. Inquiry into the allegations of professional or other misconduct of a notary. Lordship, may kindly have a glance at 13.1.
Nay, let us go serially.
My lords,
One, yes.
an inquiry into the misconduct of a notary may be initiated either suo motu by the appropriate government or on a complaint received in Form 13.
Here the complaint.
Here the complaint has been filed. Lordship, here 13.1, it is only stating the two ways by which the jurisdiction can be invoked. It is not stating that an inquiry has to be conducted as per 13.1.
No, but further clarifications come to next.
Lordship.
Every such complaint shall contain following.
Following particulars. My lordship.
Okay, that's not necessary.
Lordship.
Then appropriate government.
That they will return the complaint if it is not made within the proper parameters.
So therefore,
that is 3.
It is the preliminary inquiry say it is not maintainable, he may return it.
Lordship, no preliminary inquiry, Your Lordship. They will just see if the complaint has been made as per the rules. In fact, there is no provision for preliminary inquiry.
Proper form.
Not proper form, my lord.
So this form 13 is not complied, then it can be returned.
Returned, my lords.
Then
Your Lordship, 4 is when within 60 days of receipt of a complaint, the appropriate government shall send a copy thereof to the notary. Here, my lords, it has been sent to him. The complaint was received, then it was.
So your record shows notice has been
Notice
sent.
has been sent, Your Lordship. Notice
So
has been
13.4 complied.
My lords.
By issuing notice to the party likely to be affected.
To the notary, Your Lordship. It has been.
Yes, then
4A, Your Lordship, is suo motu initiation that is not related to the case, my lords. Then Lordship may see 13.5.
Yes.
A notary against whom an inquiry has been initiated may within 14 days of the service of him a copy of the complaint under sub-rule 4 or of the statement of the charges under sub-rule 4A as the case may be, or within such time as may be extended by the appropriate government, forward to that government a written statement in his defense verified in the same manner as a pleading in a civil suit. So here, Your Lordship, he has submitted a written statement also.
Statement comes in.
Lordship.
It will be sent to the appropriate government.
My lords. Here, Your Lordship, the notary has submitted his written statement and that has also been considered while delivering
So
the
13.5 written statement has come in.
My lords.
Hmm.
Then Your Lordship may see 13.6. This is the inquiry stage, Your Lordship.
Yes.
If on a perusal of the written statement, if any, of the notary concerned and other relevant documents and papers, the appropriate government considered that there is a prima facie case against such notary, the appropriate government shall cause an inquiry to be made in the matter by the competent authority. If the appropriate government is of the opinion that there is no prima facie case against the notary concerned, the complaint or charge shall be filed and the complainant and the notary concerned shall be informed accordingly.
So therefore, 2 options.
My lords.
If you find a prima facie case, to go into an inquiry.
Lordship.
If you don't find a prima facie case,
My lords.
only result will be intimated to parties.
Lordship.
So that is dropping of the proceeding.
Lordship.
So now, yes.
As per 13.6, Your Lordship, the prima facie case was found. That is there reflected in the order sheet.
13.6 appears.
My lords.
13.6 prima facie case established.
Established, and after that, the notice was issued, my lord. The order of the secretary is there. I have the full order sheet with me, my lords.
So, as a consequence, a further notice has been issued, you say.
My lords.
Ket tarikh re pathaiji?
Lordship, my lords, notice number 13267 dated 5/12/2018.
Has it reached the party?
Yeah, he has appeared after that, my lords. He has contested throughout the case, my lords. He was there throughout.
Then
Every opportunity of hearing has been.
Contest continues.
He has contested. That report is also there. He had a counsel who had defended him throughout the case, my lords. So
then what are the procedures of 13.6 is complied? Your submission 36 is complied.
Lordship.
Okay.
Then your lordship 7 says that every notice shall be sent by a registered post.
So that may not be relevant now.
My lords.
Because your office note says it has been issued. Not only that, he has started appearing after that.
Lordship. Through a council, yes, appeared throughout, my lords.
Then
Then Lordship 8 stated that
8.
My lords, it shall be duty of the appropriate government to place before the competent authority all facts brought to its knowledge which are relevant for the purpose of an inquiry by the competent authority. Now, my lords, 9 states that a notary who is proceeded against shall have the right to defend himself before the competent authority, either in person or through a
So
legal
therefore,
practitioner.
here the legal counsel was there.
He was there throughout, your lordship.
So 8, 9 all complied.
It has all been complied, my lords.
Then
10 states that the authority has the power to regulate the proceeding as he necessitates.
Mr. Mishra.
Yes, ma'am.
As he submits through the record, you have been noticed in the second stage.
My lord, first submission before lordship would be look at 13.6.
Yes.
13.6, my lord, I appeared till 13.6. A report was prepared behind my back. That report was never supplied to me. Lordship, can you look at 13.10?
Read again 13.6.
Lordship, look at 13.10, my lord.
13.10.
10.
No.
After 13.6, my lord, if there is a prima facie case made out against the notary, inquiry is required to be conducted.
Yes, no. 13.6. Read again. Where is the question?
If on a perusal of the written statement, if any other notary concerned and other relevant documents and papers, the appropriate government considered that there is a prima facie case against such notary, the appropriate government shall cause an inquiry. That's the content, my lord. So, cause in inquiry is stipulated under rule 10, my lord, 13.10. After 5.6, no communication, even a report which was prepared on my presence, that was never communicated to us.
So, the
My lord, I will cite judgment.
Mr. Mishra,
Yes, my lord.
the question relevant here is for 13.6, it contemplates an inquiry is to be conducted.
Lordship.
And
Yes,
if
ma'am.
you find prima facie case to proceed further.
Lordship.
Bow down, my lord.
If you don't find prima facie case, then to
Close
drop.
the case.
My lord. Yes.
So therefore, his allegation here is there is no dispute. You have been noticing him. But whether you have
Prior to
provided
13.6.
this
Prior to
inquiry
13.6.
report.
He was there throughout the inquiry report, your lordship.
No.
In his presence, the
Listen,
inquiry
you
report.
might have prepared the inquiry report, but have you provided that inquiry report to him to have his defense?
Depends and to make an inquiry.
Then inquiry you have participated.
Second inquiry.
No, 10, 13.
Second
Lordship,
inquiry.
they have admitted they
last
have not
occasion-
conducted an inquiry.
On the last
Lordship,
occasion,
kindly
my
talk to
learned
their
senior
counter.
was on the last occasion, my learned senior was submitting that there is supposed to be 2 inquiries held. In fact, the rule 13 very specifically clarifies that there will be only 1 inquiry, and then it is the prerogative of the government, the authority, whether they want to conduct another inquiry. If they feel that the case needs another.
13.6 contemplates an inquiry.
That is the first
That's all.
inquiry.
Okay.
My lordship.
Therefore, if 13.6 contemplates an inquiry,
Lordship.
then that inquiry report must be supplied to the party likely to be suffering. No, otherwise, what defense he will bring?
Lordship, I'll have to check the records whether that has been supplied.
Should I close and
Because-
both of you give your written note of submission?
Apart from that, my lord, Lordship, can you
No,
talk to
Kali,
Party?
all right, tomorrow.
I'll just, Lordship may just
Tomorrow.
grant me an object, my lords.
Tomorrow.
I'll
So,
just
sir,
verify
just
whether-
good point.
all other aspects have been thoroughly
Small
covered,
point.
my lords.
That's the small point, zero in. If inquiry as under 13.6 is conducted, whether that report will be supplied to the delinquent or not. Because
cite judgment.
the defense is only on that inquiry report. What has been found against him?
Lordship.
Okay. Tomorrow. Let's further doing tomorrow. Both of you also come prepared with your written note of submission.
My lord, insofar as the counter is concerned, they have conceded that we have not done any inquiry. It is the prerogative of the authority to make an inquiry or not to make an inquiry.
Okay.
That is their grounds.
That also.
No, that Lordship must see the counter paragraph 8, what we have stated.
Paragraph 4. Paragraph 4.
Paragraph
Just
8,
one
your
minute,
Lordship must see.
one.
Inquiry conducted against a notary in the instant case was done strictly within the parameters of Rule 13 of the Notary's Rule.
That is, look at my lord. As regards the allegation of not examining the witness or admitting the documents into evidence, it is stated that Rule 13 of the said rule grant discretion to the competent authority to do so while granting him liberty to regulate his own procedure relating to inquiry in such a manner as the court considers necessary.
Go through that and submit tomorrow.
My lord.
4 plus 6.
No, there also we have not stated that, Lordship. Paragraph 4.
They have
I'll submit
said that
tomorrow.
if they are interested in the manner they desire, they can conduct
He is
inquiry.
just making you aware.
Lordship.
So, right.
A small notary, my lord, 200 rupees, subjected to 3 years losing the license.
ये नोटारी करे कहले नोटारी
50 टका के,
करे
50
जो
टका,
माने
100 टका।
प्रैक्टिस करि पारु नाहंती
50 टका 100 टका जहाँ
How
उठियो
why
मार
should
देले,
a lawyer go to perform as a notary?
not able to not able to
Profess.
profess. That's true.
Not able to profess. See गोटे जगह रे टेबल चौकी करके बसिले
50 टका नेले
पैसा
जहाँ पाइले
सेठी
10
रोजगार
टका।
करिवे
कि देखिए हाई लो प्राइस वाला।
सीरियल चलिबो
Item 43, there is no instruction in this committee memo. has been filed.
Okay, memo has been filed. या आपण तो आर्गु करूचंती मिस्टर महापात्र काहे कि एठी आसी सकाळू हाजिरा दउचंती मिस्टर मिश्र
सब वकील बिना पैसा रे केस 5 पैसा नहीं
19 टा टेक अप करबा
45 रो आगे
22 23 मैटर सब पळेबा आफ्टर वेकेशन
Item 49, 47 रे खाली
election 44 टा नहीं सर
49 रे election proceeding has been stayed. Taken up 49.
ये हेले रहिबो छुट्टी परे करबा छुट्टी परे करबा
Last item 50.
आगे मु बर्तन
Already complied with I am filing the
44 टा चलची बसंतु टिके बसंतु आपण
Item 44, your lordship, sole petitioner died, I am filed the substitution petition.
Sole. आनंद
Copy दिया हमको.
This is an application filed bringing in the LRs of the sole petitioner. Along with power ଦେଇଛନ୍ତି
Again.
along with power of the LRs application stand allowed kain consolidated cost title kain okay there is no filing of consolidated cost title place this matter after vacation
Interim order may continue.
interim order may continue
I have served the copy.
का copy देबे
Government को देले other side.
हां दे दियंतु the consolidated cost title copy also be served on the respective councils. Interim order is extended.
Item 45.
Item 45.
No, I received copy of IA 596 just now.
नहीं आमे मिस केस को जिबानी केस टा कोन कहले
आगे
सर
जमा मिस केस को जिबानी
सर सेटा सरिया पर मु खाली पदे कहबी
रोन मोट का कहि सर
हां सर कोन
मु जानि छी सर जा कहियो मु जानि छी मु भी कहि दउ
केस रेकॉर्ड अछि
एटा कथाटा सी जति कहि देबे आपण बसिला पसंद
आगे सर निश्चय कहबे 98 रो ऑर्डर ता एति दिन पर चैलेंज
मु सेटा कहूनी
इन व्हाट सर्कमस्टेंसेस इट इज बीइंग चैलेंज मु टिके कहि दिए काइंडली हैव अ ग्लांस
कोन चैलेंज करछ
से आउटे कनेक्टेड डिटेल सेटा ता संगे आसिले भलो हो मु सेटा खाली नंबर ता दे दिबी
अछि दैट हैज अ बेरिंग
आगे ना सेटा डिस्पोज होई
मु से ऑर्डर ता कोट कर
ता ऑर्डर ता देखि देले हबो कोन
हां सर मु देखै
मु कोट करछि ऑर्डर ता पेज 7 ऑफ द रिपोर्ट
ओके ऑल राइट यू कंटिन्यू मिस्टर महांती और दीपट रे महांती जाउछन हां यस आपन कंटिन्यू डीके महांती कंटिन्यू
देयर आर सम record of rights I have annexed around 4 record of rights are there annexer 1 2 it is continuing till annexer 6 all are record of rights if a glance will be made it will be clear that the properties are standing in the name of the predecessor of the present parties
in the name of
kindly have a glance annexer 1 is standing in the name of one Purastam Rao.
Purastam Rao.
Yes, annexer 2 is also same.
Purastam Rao.
Annexer 3 is also
their successors.
But in joint recording.
Joint recording. Similarly, it's continuing annexer up to annexer 6. Now kindly have a glance at page 3 of the writ petition, the family genealogy.
Annexer 6 also, Annexer 6 re kevala Manguli Raul gala.
Yes, I will come to that. I will come to that. Kindly have a glance at the
5 porjanto nahi 4 porjanto achi sei manang nare.
Same anangnare. Even the genealogy, it will be clear, page 3 of the writ petition.
Yes.
Now this Lakshman is the original common ancestor. The two wives are Nida and Mongoli. The Mongoli last year, let's just find out the name. Now kindly have a glance. The present petitioner is the successor of this Nida, the first wife, through the name is Sandharani, the daughter of Purushottam.
Yes.
Now the property judge I have already shown. The stands recorded in the name of either Purushottam or jointly in the name of the members of their predecessors. So the claim is that this daughter Sandharani, the petitioner, he has also a share in the property. Now what has happened in the year 1998, a 37 proceeding was initiated. That is under Annexer 7. Kindly have a glance. RP case number 155 of 1998.
Yes.
In this case, Gaurahari, the grandson of the second wife, through second wife, he was the petitioner.
Yes.
Only 3 persons were added as parties: Rajanikanta, Malaya, and Urmila. First wife's only 3 successors. First wife's second son Ratnakara, then his wife and two children. The one part, the Purushottam's successors were completely omitted. Then this proceeding was continued. In this proceeding, a peculiar claim was made that there was a gift. Kindly have a glance page, running page 27, internal 3.
Yes.
About 4 to 6, 7 lines from the bottom. One gift, in the reference to a gift, it is there. Mongoli gifted the Sutland. You got it? Mongoli gifted the Sutland along with other lands according to her own will in favor of the present petitioner Gaurahari on 21/1987. With this claim of a gift deed, the number is not there, document number is not there, date so and so, it was claimed that property is his exclusive property and gifted by Mongoli. Kindly have a glance the second wife. Now, this is being allowed by the order dated under Annexer 8 on the basis of the same gift only. In the order also only date is there is no number.
Then how do you satisfy the delay?
Delay, because this was not within my knowledge, I have stated. 2 of the brothers, of course, they at one point of time tried to recall that order, filing application before the same authority. That came before this honorable court, which my learned senior was referring to. Kindly have a glance. It was ultimately held that the authority had no power to review, therefore the petition is not maintainable. That as I have quoted the order at page 7.
That happened when?
That happened in 2006.
Then also somebody could have come in High Court.
The writ petition also I was not added as party. Writ petition also I was not a party. And I got after coming to know about the incident, kindly have a glance at page page.
But at least establish when you have got this copy.
Kindly have a glance page 35, Annexer 9. When I inquired into the matter to find out.
No, Mr. Mahanti, you say you are not aware all through.
Okay.
And even if some party has come to High Court,
yes,
you are not a party, therefore you can't be conscious of such proceeding.
Yes,
now establish. When did you got this Annexer 8?
Annexer 8. Annexer 8 I got it subsequently. Annexer 8. Annexer 8 along with Annexer 9 also.
When you have got this?
Yes, the date is there. Certified copy.
Annexer 9, page 35. This is This is a nil encumbrance certificate, that's different.
There is,
When you got this certified copy, at least let us know.
that date that must be available in the original because backside.
କେମିତି ହବନି ଆମର ତ ସବୁଥିରେ ରହିବା କଥା date of application,
ଏଟା କଣ
date of compliance, date
ସେଇଟା
of payment of court fee.
original ଟାରେ ଥିବ ସେଟା ବୋଧେ.
Original କିଛି ନାହିଁ. How can this be there? ଦିଅ ତାଙ୍କୁ ଦିଅ. ଗୋଟେ ଗାର ପଡିକିରି ତା ଭିତରେ ସବୁ ଲେଖା ହେଇଥାଏ.
ଲେଖା ହେଇଥିବ.
So that delay condonation that is a matter to be considered.
No, this was in fact obtained from the writ petition, the earlier writ petition. That is
Then ହବନି.
earlier
ହେଲା ଶୁଣନ୍ତୁ earlier writ petition ହେଲେ ବି ତ High Court ଦବ ନା କେବେ ଆପଣ
High Court yes. That is available.
High Court ର copy application ଟା ଦେଖାନ୍ତୁ କେବେ apply କଲେ ଆପଣ.
ମୁଁ ଦେଖେଇ ଦଉଛି. It is in 2019.
Therefore there must be some proof.
Yes, it is there. 2019.
So 2019 hele your submission that I was all through not aware of this.
This is also 2019. And kindly have a glance the last page why I was referring to Annex 9.
This should be there.
Yes.
ଆପଣ यार part ଟେ file କରି
ମୁଁ
ଦେଇଛନ୍ତି.
ସେ order ଟା କାଢିକି ନେଇଛି.
କାଢିକି ଆଦରୁ file କରି ଦେଇଛନ୍ତି. It was applied on 28/1 and you got it on 2/2/19 and you filed the writ accordingly.
19 नो फाइल କରିଛି.
ତଥାପି 7 ମାସ 8 ମାସ ଅପେକ୍ଷା କରିଛନ୍ତି.
ସେଟା encumbrance ଟା Annex 9. That on that particular date there is no gift deed.
Mr. Mahanti, let the matter go back.
ମୁଁ opportunity ଗୋଟେ ଦିଆ ହଉ.
Let the matter go back.
ମୁଁ ଟିକେ ଖାଲି କହିବି.
Cost ଦିଆ ହବ.
ନା ମୁଁ ଟିକେ ଖାଲି ଗୋଟିଏ ସେଣ୍ଟେନ୍ସ କହିବି. Sir, generally action. Page 3 generally.
I'll not touch the merit. Question here is, if a party is not given a chance of contest.
से ब्रांच रो समस्त अपियर कले. समस्त कहिचंती इम्पुन ऑर्डर धाड़िए कहिचंती. समस्त केवल संध्या रे छाड़ी गिरी.
सरला त से तो करि नै हो. से तो कर नै हो.
हां सर.
Therefore let the matter go back. जान तारीख फिक्स कर दूची अपियर करंतु. Let there be a contest and then get order. At the submission.
If necessary, others will be made parties.
No, सब reopen हबो.
ना से रिवीजन ने तांको ब्रांच रो समस्त पार्टी इन तांको भी पार्टी करा जी. कने आउ की आसी कहबो जे आमे पार्टी.
हां आपण करना दी मु रेकॉर्ड कर देबी. You want to bring all other interested persons as party.
आगे.
So let everybody inform. Yes. Remind कर दो. At the आपको आओ अभी क्या डाकिया. Okay, all right, let us conclude. At the submission of respective councils, the petition involved the following prayer. Vasan. Background involving the case is a proceeding under section 37(1) of the OCH and PFL Act was brought to the competent forum in the year by Annexure 7 in the year 98, registered as RP 155 of 1998. Reading through the cause title in the RP case 155/98, judgment kariba. Taking this court to the genealogy brought at page 3 of the brief. The Mahanti Learned Counsel appearing for the petitioner brings to the notice of the court that even though the petitioner herein is one of the co-sharers in the disputed property. This RP, this 37-1 proceeding was contested behind our back. And finally decided in favor of the petitioners therein by the necessary. Annexure 8 is appearing to have been passed on. The order by Annexure 8 appears to have been passed on 22nd June 98. Coming to answer as to the reason in bringing a writ application in 2019. Sri Mahanti, taking to the background involved herein, brought to the notice of the court that one of the party attempted to bring a review of the order herein being rejected. A writ petition was brought to this court in OJC 7851 of 99, which came to be disposed of on 9/8/2006 in the rejection of the application. It is made clear that the writ petition was by some other party and not by the petitioner. It is only after, okay, it is at this stage taking this court to the documents from Annexure 1 to 5. Attempt is made to establish that property all through remained in the ancestors of the petitioner. It is claimed only after coming to know that there has been certain development through 37-1 proceeding. The petitioner, and after coming to know that there has been further litigation through OJC 7851 of 99, petitioner, to know the details of the litigation, applied for certified copy of the writ application along with the orders therein. Also, the documents appended therein. Taking this court to the date of application being 28/1/2019 and date of delivery 2/2/2019, it is contended after getting the 37 order as well as the development through High Court, petitioner applied for a non-encumbrance, nil certificate of encumbrance of property by Annexure 9 to find the position of the property, which copy was supplied to the petitioner on 9/8/19 and the writ petition came to be filed on 16/8/19. It is for the expiatory order, for the behind back, obtaining of order behind the back of the petitioner. The Mahanti contended the interim order should be interfered and remitted back for reconsideration of the dispute in the involvement of the party in interest, the petitioner hearing. Okay, Sri Maheshwar Mahanti, learned counsel appearing for the OP, taking again to the genealogy and the cause title in the RP case, attempted to submit that it is not a complete case, it's not a case without involvement of the interested party, decided without involvement of the interested parties. The some of the ancestors having been involved in the 37 proceeding, it should be presumed that all the parties were involved in the 37-1 proceeding, requiring no opening of the proceeding any further. Mahanti also took help of the attempt of the one of the one of the course errors through OGC 7851 of 99 and submitted the present writ petition is barred by res judicata. Considering the rival contentions of the parties, this court, on perusal of the petition under section 37(1) of the OCH and PFL Act, read together with the disclosures in the Annex 1 to 5, finds petitioner undisputably had interest in the property. There is also no denial that petitioner was never made a party to the proceeding under section 37(1) of the OCH PFL Act. It is taking into account the question of application of res judicata being raised by Mahanti Counsel for Private Opposite Parties. On perusal of the dispute involved in OGC 7851 of 19, decided on 9/8/2006, this court finds petitioner was not the applicant there. Therefore, any development therein doesn't bind the petitioner. Further, coming to the question of bringing the writ application up with inordinate delay, this court, for the recording herein above, that petitioner was never a party to such proceeding, either of the proceedings in the 37(1) or in the writ petition, finds petitioner, after coming to know of such development, applying copy of writ along with the other copies by making application, copy application to this court on 28/1/19 and getting all such clues on 2/2/19. It is here this court also find petitioner, after getting the details of the history of litigations involving the disputed property, attempted to know the position of the property and in the process applies for a copy of nil encumbrance on property, nil certificate of encumbrance on property on form number 25, and by the annexure 9 gets the certified copy of the same only on 9/8/2019. This writ petition was brought on 16/8/19. This court therefore satisfies with the petitioner submission of the learned counsel involving delay in bringing such litigation. Okay, for this court find the 37(1) proceeding brought without involvement of the petitioner and Annex 1 to 4 at least establishing petitioner has a right over the disputed property, prima facie establishing the right over the disputed property, and the decision by the Annex 7 decided behind the back of the petitioner. The order at Annex 7 remain unsustainable. In the process, this court interferes in the order at Annex 7, including the order at Annex 8, set aside the same. However, for there is fresh requirement of fresh disposal of the RP case number 155/98, remitting the matter to the Joint Commissioner Settlement and Consolidation Odisha and or the competent authority for the time being.
Now at
Direct both the parties in contest to appear before the competent authority at least along with the certified copy of order at least on 17th of May this court also have, and take date of fresh hearing. Okay, it may be open to the petitioner hearing to bring its objection to the 37 proceeding on the date of appearance. This court seems fine from NSO 1 to 4. There are so many stakeholders involving the property. Parties on proper advice may bring any other party likely to be affected to the fora of consideration. Then a writ petition succeeds, but however with an order of remand. Okay, in the circumstances,
for delay
no
part.
order has to pass.
Not for delay part, my lord. 98 impugned order for delay part.
Delay part I have observed.
No cost.
I have dealt with that. No, there's a bona fide. Yes.
My lord, the joint commission not Bhubaneswar at Baleshwar.
Lekhichi setipai either joint commissioner or the competent authority for
Baleshwar
time.
specific person. Baleshwar person.
Okay, correction kar do hala. Ise jo ad likhla, it is at this stage or the competent authority pakra at this stage. Mr. Mahanti mane Mysore Mahanti brings to the notice of the court presently the proceeding lies before the
Additional commissioner, consultant settlement
additional
Baleshwar.
commissioner consolidation
And settlement Baleshwar.
and settlement Baleshwar. Hala. Yes.
Item 47.
Sub vacation after
ମୁଁ ଖାଲି 10th July date ମାଗୁଥିଲି ଆଉ କିଛି ନାହିଁ
10th July.
July after vacation
10th July.
item 40
Item 49.
Next week, man.
ଆଉ ଯିଏ mention କରିବ not press କରିଦେବି ସବୁ vacation ପରକୁ ଯିବ ଯାହାର interim order ଥିବ continue କରିବ ଆଉ ଯଦି କିଏ mention କରିବେ not press ଲେଖିବି
Activity has to be filed, that it may be accepted, my lord.
document ଡକା ହଉଛି ତଥାପି ମଡେଇ ପଡୁଛନ୍ତି ଆଜ୍ଞା ଆମର ନେଇଯାଆନ୍ତି ଛାଡିବେନି ଆଜ୍ଞା ସକାଳେ division bench କରିସାରିଲା ପରେ ହାଲିଆ ହେଇଯାଏ ମଣିଷ
Not to withdraw, my lords. He has filed the complaints affidavit, my lords. The copy was sought to me. Let it come next week. I will take instruction, my lords.
ଲେଖି ଦଉଛି comply ହେଇଗଲାଣି ବୋଲି
No, comply him. They have violated the order, not complaints, your lords. I will take instruction, my lords. They have violated your lordship's order.
service କରିଛନ୍ତି ଆପଣଙ୍କୁ
Just today I served.
Serve
I received today, my lords.
ଛୁଟି ପରେ ଆସୁ
Again.
ଫାଇଲ କରିଦିଅନ୍ତୁ compliance report file be kept on record. This court records the objection of Mr. Biswanath that in fact there is no compliance. This aspect shall be considered on the next hearing after vacation karibo 3rd week.